Sir, good morning po. Magpe-present na po.
Yes.
Hi, my name is Diljan Declarado, and this is our first report, Republic Act 544. So this Republic Act 544 was made to regulate the practice of civil engineering in the Philippines. It was approved on June 17, 1950, and there are changes made in this Republic Act amended by RA 1582, and naaprubahan yung mga changes na yon noong June 16 na 1956. So I'll just give a brief summary sa sections 1 to 6 para sa Republic Act na to. So, sabi, this Republic Act will be known as Civil Engineering Law, and yung mga services ng civil engineer na nakalahad dito ay ang consultation, design, preparation of plans, specifications, estimates, erection, installation and supervision of construction of streets, bridges, highways, railroads, airports, and hangars, port works, canals, river and shore improvements, lighthouses and dry docks, buildings, fixed structure for irrigation, flood protection, drainage, water supply and sewage works, demolition of permanent structures and tunnels. So after 30 days na naprobahan yung RA 544, yun din yung sinilang yung Board of Examiners for Civil Engineers or tinatawag nilang board sa Republic Act na to. So the board has three members, meron siyang chairman and two members, and they were appointed by the President of the Philippines, and yung mga na-appoint na yun ay inirecommend ng Professional Regulation Commission or PRC. So ito yung qualifications para ang civil engineer ay pwede maging part ng board. So kailangan siya ay at least 30 years old na syempre na nakatira sa Pilipinas, graduate and registered as a civil engineer. Then nagampanan niya yung pagiging civil engineer niya for not less than 10 years prior to his or her appointment. Then, kailangan hindi siya miyembro or nagkakaroon ng interest na sumali sa or any relation sa school or any institute, college, or university kung saan tinuturo ang civil engineering nga sa course. And if ever man na siya ay former professor or instructor sa isang college, kailangan tumigil na siya sa pagtuturo for 3 consecutive years. So as of now, ito yung mga current members ng the board ayon sa PRC.
So, ang next naman is Section 7. So, yung sinasabi lang dito is yung board ay dapat mag-submit to the PRC ng kanilang detailed report of their activities or proceedings at the end of a fiscal year or every 12 months. And then next is Article 3, Examination and Registration. So, sa Section 8, ang sinasabi lang dito is dapat yung mga applicants for the practice of civil engineering ay pumasa sa isang technical examination. So, sa Section 9 naman, yung sabi dito is dapat yung examination for the civil engineers or yung board exam ay dapat ganapin sa Manila or City of Manila at dapat yung araw na yun ay hindi tatapat sa holiday or kung tumapat man siya sa holiday, dapat siyang ganapin the next day. So, next naman is Section 10. So, yung sabi dito is dapat yung mga applicants for the civil engineering practice ay examined by the board in the following subjects. So, yung mga subject na yun is mathematics, hydraulics, surveying, and design and construction. So, next naman is Section 11. So, yung sabi dito is dapat daw yung Commissioner of Professional Regulation Commission ang siyang maging executive officer and siya rin dapat yung mag-conduct ng examination and dapat din siyang mag-designate ng isang subordinate para maging secretary and custodian of all records including examination papers and etc. So sa section 12 naman, so dito is nakalist yung mga qualifications na kailangan ng mga applicants na dapat nilang i-complete prior the examination. So una is at least 20 years old, pangalawa is citizen of the Philippines, pangatlo ay may good reputation and moral character. And then lastly is dapat graduate ng isang 4-year course in civil engineering.
Next is Section 13, which is Oath of the Civil Engineers. States that all successful candidates in the examination shall be required to take a professional oath before the Board of the Civil Engineers or other government official authorized to administer oaths prior to entering upon the practice of the civil engineering profession. So, ang Section 13 ay sinasabi dito na we as a civil engineers, we need to take oaths or panunumpa with the board itself dahil ang board ay mayroong regulation na kailangan natin sundin at mga prior objective na dapat nating kunin. Next is Section 14, which is seal and use of the seal. States that all registered civil engineers shall obtain a seal that directly designed by the board, and it is unlawful for anyone to stamp or seal any documents with said seal after registrant's certificate has expired or been revoked, unless said certificate has been renewed. So yun nga, sabi nga ng Section 14 is bawal tayong gumamit or mag-stamp or mag-steal ng any documents once na ang certificate natin or ang seal natin ay expired na or na-revoke na. Dahil saan ba ginagamit ang seal? We as a civil engineers, we use seal sa ating mga plans and specifications and of course, other documents. Next is Section 15, which is exemption from the registrations. First, military personnel stationed in the Philippines who provide civil engineer services for the U.S. and or the Philippines. Next is civil engineers and specialists hired by the government to design and construct permanent buildings except for those under development. It applies to all public buildings in the Philippines. Second is a new law in the Philippines has made it illegal to build wooden structure without having a civil engineer. It also prohibits building that exceeds the space requirement within the law. There is no provision for building an extension or enlargement of the house also. The third is this act does not prevent draftsmen, student clerk, or superintendents lawfully engaged in the practice of civil engineering under the provision of this act. Then the fourth one is nothing in this act prevents anyone who lawfully engage in the practice of maestro de obras or master of the builders prior to its approval for continuing to do so. Okay. So number 5 is nor shall anything in this act prevent professional architects and engineers to practice their professions. Next is section 16, which is refusal to use certificate. The board for civil engineers will not issue a certificate to any person convicted by a court of any criminal offenses involving moral turpitude or guilty of immoral or dishonorable conduct or to people of unsound mind. So yun nga, ang board is hindi i-issue kayo i-issuehan ng certificate if you have a criminal case pending man yan or past na. Dahil ang board is mahigpit sa mga ganitong bagay. They sasalain talaga nila ang mga makakuha ng certificate because ang certificate is a privilege for being a civil engineer. Next is section 17, which is suspension and revocation of certificates. States that the board shall have the power after due notice and hearing to suspend or revoke the certificate of registration for any cause mentioned in the preceding section. So yun nga, section 17, kung meron man na mag-i-issue ng certificate, meron din tayong pagtatanggal or pagsususpense ng certificate. Ang board ay merong kapangyarihan na tanggalin kung ano man yung certificate na binigay sa'yo dahil in case na meron kang nagawang mali or kriminalidad, we have the jurisdiction or the board we have the jurisdiction to revoke your certificate by the process of jurisdiction itself. Next, we have section 18, the issue and replacement of certificates. The board may revoke the certificate of registration of a registrant after 1 year from the date of revocation. The registrant may then apply for a new certificate from the registrant concerned. If successful, the applicant rather may be exempt from taking the required examination in the future. So, sa section 17, meron tayong suspension and revocation. Section 18 naman, we have the reissue or replacement in case naman na may mawala or masira yung certificate. And kung expired man or na-revocate ang certificates mo, you have the privilege to renew your existing certificate.
Section 19, Transitory Provisions. Any person desiring to practice the profession of civil engineering shall be required to obtain a certificate of registration in the manner and under the conditions hereinafter provided. So, sabi, in this section, yung gusto raw mag-work as civil engineer professional ay kailangan mag-undergo muna sa required requirements to become as one. So, you need to graduate with the course of civil engineering and mag-take ng board exam para makakuha ng certificate of registration, which this certificate of registration ang magiging proof mo na ikaw ay registered na and qualified to work as civil engineer professional. So next is Article 4, Enforcement of Act and Penal Provisions. Section 20, Enforcement of the Act by Officers of the Law. Shall be the duty of all duty constituted law officers of the national, provincial, city and municipal governments or any political subdivisions thereof to enforce the provisions of this act and to prosecute any person violating the same. So, it's a duty daw ng law officers from either national, provincial, city, and municipal government or any political subdivision is yung i-enforce yung laws, yung civil engineering laws, and sila rin yung responsible na i-arrest or prosecute yung mga nag-violate sa laws na yon within their areas. Section 21, Registration Required. Unless exempt from registration, no person shall practice or offer to practice civil engineering in the Philippines without having obtained the proper certificate of registration from the Board of Civil Engineers. So, sabi dito, hindi ka raw pwedeng mag-undergo sa mga practice of civil engineers or mag-work as civil engineer nang hindi dumadaan sa tamang proseso, which is yun nga, yung graduate sa course na civil engineering at mag-take at pumasa sa board exams para maging isang registered civil engineer. Section 22, Penal Provisions. Any person who shall violate any of the provision of this act shall be guilty of a misdemeanor and shall upon conviction be sentenced to a fine of not less than 500 pesos nor more than 2,000 pesos, or to suffer imprisonment for a period of not less than 6 months, not more than 1 year, or both in the discretion of the court. So, those individuals daw na magwo-work ng works of civil engineer professional ng walang license, or yung nag-violate na nagwo-work pa rin as civil engineer kahit na yung license nila as suspended, at may iba pa na gumagamit ng fake license, sila daw ay magkakaroon ng penalty. Either magbabayad sila ng hindi bababa sa 500 at hindi pesos at hindi tataas sa 2,000 pesos. Or mas worse pa is imprisonment. Yung imprisonment naman is hindi daw bababa sa 6 months or not more than a year. Depende rin daw yon sa naging violation or sa magiging judgment of the court. Next is Article 5, Miscellaneous Provisions. Section 23, Preparation of Plans and Supervisions of Construction by Registered Civil Engineer. It shall be unlawful for any person to order or otherwise cause the construction, reconstruction, or alteration of any building or structure intended for public gathering and any other engineering structures mentioned in Section 2 of this Act, unless the designs, plans, and specification of same have been prepared under the responsible charge of and signed and sealed by a registered civil engineer. So, hindi raw magiging valid yung preparation ng plano, yung mga design, at magiging against daw to sa law, yung pagsusupervise ng designs, plans, hanggang sa construction, kung hindi isang civil engineer professional yung in charge dito. So, lahat ng tao kayang mag-design at magplano, pero hindi ibig sabihin nun lahat pwedeng pumirma. Kasi ito ay trabaho lamang ng isang civil engineer professional. Section 24. Nobody shall be a member or partner of such firm, partnership, or association unless he is duly licensed civil engineer or architect. And the members who are civil engineers shall only render work and services proper for a civil engineer as defined in this Act. And the members who are architects shall only render work and services proper for an architect as defined in the law regulating the practice of architecture. Individual members of such firms, partnership, or association shall be responsible for their own respective acts. May mga associations like PICE, which is, yung PICE is Association of Civil Engineers. So, hindi raw magiging member ang isang individual sa ganitong associations or corporation unless they are already registered as one or simply meron na silang license. Binanggit din sa section na to na ang work daw ng isang civil engineer ay exclusive lang sa civil engineers. And works ng architects ay exclusive for architects lang, na meaning yung individual members daw ng specific association ay responsible lang sa acts related sa specialization or natapos nila. Yun lang.
So in RA number 544, Article 5, Section 25 to 29. In Section 25, which is the reciprocity requirement, states that no person who is not a citizen of the Philippines at the time he applies to take the examination shall be allowed to take it unless he can prove in the manner provided by the rules of court. So, if you are going to take a board exam, kailangan po ay isa kang citizen sa country, nation, or state kung saan ka po mag-exam. And kung ikaw ay hindi naman citizen doon sa country or state kung saan ka mag-exam, hindi ka pwede mag-exam unless approved in the manner provided by the rules of court. And after po mag-take ng exam, they are allowed to practice civil engineering without restriction, and they are highly recognized by the government of the Philippines as a degree holder in civil engineering. Kasunod po ay if he is not a citizen of the Philippines and was admitted to the practice of a profession in the Philippines, his active practice in that profession, either in Philippines or in state or country where he was practicing his profession, shall not have been interrupted for a period of 2 years or more, and that the country or state from which he comes allow the citizen of the Philippines by specific provision of law to practice the same profession without restriction or on terms of strict and absolute equality. So, if you are not a citizen in the country naman po kung saan ka mag-take ng exam, you should practice civil engineering in a span of 2 years or more actively before you take the board examination kung in the country kung saan ka po mag-exam. So then after that, they can practice the civil engineering in that country or state without restriction or on terms of strict and absolute equality. So kung hindi ka po citizen ng Philippines or ng country na yon kung saan ka mag-exam, kailangan mo mag-practice ng 2 years in civil engineering before taking the exam. And after that, mare-recognize na din po sila na citizen ng Philippines na civil engineering. Section 26, which is the roster of civil engineers, states that a roster showing the names and places of business of all registered civil engineers shall be prepared by the Commissioner of PRC, the Professional Regulation Commission, periodically but at least once a year. So, sabi po dito, a list of names and businesses of civil engineers shall be prepared only by the PRC and kailangang i-update ito occasionally or palagi na hindi bababa sa once a year po. And the copies of this roster shall be placed on file with the PRC and furnished to all department heads, mayors of all chartered cities, to the Director of Public Works, to such other bureaus, government entities or agencies, and municipal and provincial authorities as may be deemed necessarily to the public upon request. So, the copies of the list shall be disseminated po in all department heads, mayors ng city, and to the Directors of Public Works and also po sa public upon its request. So, in Section 27 po, which is repeal, states that all laws, part of laws, orders, ordinances, or regulations in conflict with the provision hereof, including parts or acts of Act Number 2985 as amended as pertains to the practice of civil engineering are hereby repealed except the provision of Act Number 3159 amending Act Number 2985 pertaining to the practice of maestro de obra. So, sinasabi lang po dito na yung any laws, parts of law, orders, or regulation po na nagkaka-conflict sa mga provision po na nabanggit, kasama na po yung ilang parts sa Act Number 2985, which is the Engineering and Architecture Law, ay pinapawalang bisa po. Except sa provision of Act Number 3159 na nagpa-practice ng mga master builders or maestro de obras, sila po yung mga foreman, laborers, and anyone who's building structure. So in Section 28 po, the Construction of Act states that if any part of section of this act shall be declared unconstitutional, such declaration shall not invalidate the other provision hereof. So sinasabi lang po dyan na kung may mga conflict po or may mga part po sa section na ito na unconstitutional, hindi po nito maapektuhan yung ibang provision na nasabi po dito sa RA 544. Lastly po, Section 29 Effectivity states that this act shall take effect upon its approval. Approved June 17, 1950 as amended by RA number 1582, approved on June 16, 1956. So sabi lang po dito, lahat na nakalagay sa RA 44 ay magiging epektibo lamang sa oras na ito ay naaprubahan na. So RA 544 was approved on June 17, 1956 as amended by RA number 1582. It was approved on June 16, 1956. So ang RA 544 po was implemented up until now.
Good morning. So ngayon, ang pag-uusapan natin ay ang Government Procurement Act or RA 9184. So ano nga ba yung nilalaman nito? Ano nga ba yung ibig sabihin nito? At ano nga ba yung mga scope and application nito? So, let's start. For background, since the passage of the RA 9184, the Government Procurement Policy Board has issued two IRRs. Ito yung IRRA, which took effect on October 8, 2003, and the revised IRR, which took effect on September 2, 2009. So, ito yung dalawa na unang na-issue ng Government Procurement Policy Board. And then, noong August 29, 2016, the Government Procurement Policy Board finally approved the 2016 revised implementing rules and regulation of RA 9184. So, the 2016 revised implementing rules and regulation of Republic Act number 9184, otherwise known as the Government Procurement Reform Act. So, dito na nagsimula yung effect ng RA 9184. Legal basis of RA 9184 or the Government Procurement Reform Act. It is an act providing for the modernization, regulation, and standardization of the procurement activities of the government and for other purposes. So, ito yung mga um, act which is nagpro-provide siya ng modernization and regulation and standardization para sa mga procurement activities ng mga gobyerno or ng other organization or businesses. So, it is more about procurement activities para mas mapadali, mas maging maayos, maging ma-regulate ng tama yung mga procurement activities. So, ano nga ba yung procurement? Procurement is the act of obtaining goods or services typically for business purposes. So, ito yung act wherein mag-o-obtain or kuha ka or bibili ka ng mga goods or services pero more on pang business purposes because parang mas goal nila yung long-term and win-win relationship with the supplier. It is the process of identifying, shortlisting, selecting, and acquiring suitable goods or services through direct purchase, competitive bidding, and or tendering process. So, sobrang mahabang proseso to at hindi lang siya basta-basta nagdedesisyon, kundi ito ay isang proseso which is i-identify mo, shortlist, and kailangan mo mag-select and mag-acquire na suitable sa goods or services na kailangan ng kumpanya nyo. Yun, pwede kang gumawa ng direct purchase, competitive bidding, or tendering process. So, if someone says they work in procurement, it means they spend a lot of time navigating the supply chain to get what their company needs. So, kapag sinabi nila na they are work in procurement, talagang mag-i-spend sila ng maraming oras at sapat na oras para mas ma-identify or ma-select kung ano yung mga bagay na suitable dun sa needs ng kumpanya nila. Hindi lang siya basta-basta desisyon, kundi isang mahabang proseso to at binibigyan talaga or pinagtutuunan ng pansin kasi there is a difference between yung pag-purchase lang dun sa procurement. Talagang malaking bagay ito, lalo na sa mga kumpanya, sa mga gobyerno, ganyan. Scope and applications must be used for all procurement activities by the government of the Philippines and all its branches and instrumentalities including GOCCs, GFIs, SUCs, and LGUs. It shall apply to the procurement of goods and services, infrastructure projects, and consulting services, regardless of source of funds, whether local or foreign. So itong act na to is nag-a-apply sa mga procurement of goods and services. Yun nga, 'di ba? It is a process, and para sa mga infrastructure project, para sa mga contractors, engineers like us, yung mga civil engineers, and yung para sa mga consulting services, and yun, pwede itong gamitin ng mga gobyerno dito sa Pilipinas by all branches and instrumentalities of government, its departments, offices, and agencies, including yung mga government-owned or yung mga controlled corporation, local man yan or foreign. So yun lang.
Governing Principles on Government Procurement. Principles of Government Procurement. Transparency, competitiveness, streamlining, system of accountability, and public monitoring. Transparency. Wide dissemination of bid opportunities and the participation of pertinent non-government organizations. Proper documentation and maintenance of records. Dapat maraming tao ang nakakaalam kapag merong isang certain project. Dapat aware sila or yung public na para makagawa sila ng steps kung sakali na interested sila. And to promote transparency and efficiency, yung information and communications technology ay dapat nagagamit para maisagawa yung procurement methods. Kasama na dito yung pagpapaalam sa public ng mga details. At para maging posible yun, there shall be a single portal that shall serve as the primary source of information on all government procurement. Meron lang dapat isang portal na naglalaman or pwedeng pagbasihan ng legit information for the government procurement. So bakit? Para hindi naliligaw yung mga tao sa kung ano ba ang dapat nilang paniwalaan at para hindi sila naloloko. Kasi napakadali nang magkalat ng mga maling informations at pwede itong pagsimulan ng misunderstandings. Yung portal na yon ay tinatawag na GOPOMR or the Government of the Philippines Official Merchants Registry. This shall be the centralized electronic database of merchants for purpose of government electronic procurement. Nandito yung mga announcement na naglalaman ng sufficient details for interested contractors, suppliers, and service providers para malaman if they are qualified to compete. And kung sakali na mayroong changes sa solicitation documents, lahat ng stakeholders ay kailangan ma-notified gamit yung portal na yun lang para yung mga interested na contractors, suppliers, or service providers ay makakagawa agad ng actions to comply with the change. Next is the competitiveness. Extending equal opportunity to enable private contracting parties who are eligible and qualified to participate in competitive bidding. The Philippine Government Electronic Procurement System or PhilGEPS office shall not determine the eligibility of merchants. The PhilGEPS office's evaluation of the eligibility requirements shall be for the sole purpose of determining the approval or disapproval of the merchant's applications for registration. So sabi dito, yung eligibility requirements ng mga merchants ay para lamang sa approval or disapproval ng application nila for the registration. So kaya dapat yung competitive bidding ay open kahit sa mga private contracting parties. Kung may kakayanan naman silang mag-compete and qualified naman sila. Yung procurement requirements dapat na ipapakalat or na ipapaalam sa maraming tao para tumaas ang chance na magkaroon ng good market response na magli-lead to the award of competitively priced contracts. Pero, hindi lahat ng contracts ay ina-award using the competitive process dahil minsan, nakadepende din sa kung gaano ba ka-urgent yung procurement method na gagamitin para ma-fulfill yung specific na requirement. Next is the streamlining. must be simple and made adaptable to advances in modern technology in order to ensure an effective and efficient method. Kailangan yung government procurement ay madaling maintindihan ng lahat para maging effective at walang nasasayang na oras para maisagawa yung mga method. Para hindi na din makapag-cause ng delay kasi halimbawa, magkakaroon ng bidding and then yung nakalagay sa announcement na mga kailangang requirements or kailangang gawin ay hindi clear or hindi maintindihan ng lahat. So magkakaroon pa ng misunderstanding. And except for confidential defense procurements, the results of procurement process should be published and made available on relevant websites. In addition, government procurement information, except for confidential or proprietary information, should be open to all on a restricted access basis. Yung result ng procurement process ay dapat na ipapaalam sa iba or open sa lahat para pwede itong gawing basis sa mga susunod pang process. And then the system of accountability. Public officials directly or indirectly involved in the procurement process are responsible and liable for their actions relative thereto. Yung mga public officials na involved sa procurement process ay responsible sa mga mangyayaring hakbang kasi bahagi sila ng pag-i-implement ng procurement contracts. So here are some ways of handling of confidential information. The receiving party shall maintain the secrecy of the disclosing party's confidential information. Yung naka-receive ng mga documents and information ay dapat i-maintain ang pagiging secret ng mga confidential information. Kasi confidential nga. May reason kung bakit ito ay tinatago or kung bakit hindi ito ipinapaalam sa public. Kasi for privacy na yon ng may-ari ng information. And the receiving party shall be prohibited from using the confidential information for purposes other than compliance with its obligations as an observer under Republic Act 9184 and its implementing rules and regulations. Yung receiving party, dapat di nila ginagamit yung mga info na nakokolekta o nalaman nila para sa ibang purpose maliban na lamang kung kailangan itong gamitin base sa napagkasundoan nila. And other than that, wala silang karapatan or hindi sila allowed na gamitin ito para sa iba pang rason. Access to confidential information of the disclosing party shall only be granted by the receiving party to its employees or authorized representatives. Yung confidential information, dapat ang nakakaalam lamang ay yung mga employees nung receiving party para safe at hindi kumalat yung mga confidential info. Kasi may mga times na merong mga iba syempre nag-iimbestiga na unauthorized person or nangangalap lang ng mga information para sa pansariling purpose lang. So, kapag nalaman nila yung mga confidential info, pwede makapagpahamak yun sa disclosing party at magkakaroon pa ng problema. Public monitoring reports. Submission to GPPB, observers from NGOs, POs, and other public and private sectors. Para mag-guarantee na yung mga contracts awarded ay according to the Republic Act at sa mga specifications, meron tayong GPPB data, or the Government Procurement Policy Board. When consolidated into a national database, information from the annual PMR will serve as a source of national procurement statistics, and the Government Procurement Policy Board can use the data to analyze performance, trends, and reform-related issues. Kailangan yung mga information na nakalagay sa PMR ay ginagamit para madaling ma-analyze yung mga performance. At nakapaloob na din dito yung mga statistics. Naglalaman ito ng record na pwedeng gamitin sa pagsasaayos ng issues at pag-a-analyze na rin ng trends. The Procurement Monitoring Report or PMR is a semestral report on procurement activities specified in the annual procurement plan, whether ongoing and completed. PMR major activities: holding of the pre-procurement conference, issuance of notice of award, approval of the contract, delivery or completion, acceptance or turnover, standard and actual time for each major procurement activities.
So, RA number 9184, Procurement Organization. So, na-discuss naman na yata ang background and some of the insights about RA number 9184. So, for my part is I'm going to be discussing about the procurement organization. What is it? Its responsibilities, its functions, and other more relevant of this procurement organization. Procurement organization. So, what is it? Basically, it is an organized body of people with particular purpose. Ito yung mga pinagsama-samang members na may mga position and specialty sa organization. And binubuo itong procurement organization nga may mga people with purpose and what you call this, yung talagang may ginagawa dun sa organization nila. May talagang naka-pinpoint na gagawin sa organization nila. So, a procurement team structure refers to a composition of roles, duties, and responsibilities. So, our procurement organization is, ang mga nasa loob nito is members na may roles, may duties, may responsibilities, and pinahalagaan ng kanilang mga ginagawa. So, it identifies the key positions that provide successful purchasing management process. So, it is one of the most important key position or key function in RA or in this RA 9184. For the back organizational structure or the BAC. So, ano nga ba yung meaning nito before we proceed? Ano nga ba yung meaning ng back or BAC? So, in bidding, it is simply members of the bids and awards or back. And it shall have at least 5 members but not more than 7 members. So, yung organizational structure nila is somewhat like this. So, back organizational structure. So, it consists of HOPE, PWG, Bids and Awards Committee or back, Chairman, Vice Chairman, and members, BAC Secretariat, Procurement Units, the end users, and lastly, the observers. So, yung isa is COA, yung isa is NGO, and isa is private sector. So, yung mga initials sa to like HOPE, HOPE, PWG, malalaman natin yung meaning or malalaman natin yung mga responsibilities nila and yung functions nila as we proceed to the topic. Ito nga mga chairman, vice chairman, and members, yung mga bids and awards, as we proceed to the topic, malalaman natin. And itong functions and ano nga ba kung kahalaga nitong BAC organizational structures, malalaman din natin kung bakit nga ba natin ito kailangan as we proceed and as we discuss the topic. So, proceeding on to the responsibilities of the BAC or BAC. So, the first one is, it is recommend method of procurement. So, ano nga ba yung sabihin ng procurement? So, it is the act of obtaining good service. So, recommended daw yung method ng BAC organizational structure as a good service. So, hindi naman siya ma-recommend or hindi naman siyang magiging responsibility ng BAC kung hindi naman magiging good service ang BAC na to. So, furthermore, so it create TWG. So, ito na yung TWG. Ano nga ba meaning ng TWG? It is a technical working group. So, anong meaning ng technical working group? Let's further elaborate it. So, it is an ad hoc group of experts on particular topic who work together on a specific goal. So, nagkatrabaho din sila para sa certain goal. Focus lang sa goal mo, parang ganun, particular topic. So, next one is advertise, post invitation to bid. So, ina-advertise nila, ina-announce nila kung may bidding ba, post invitation to bid. Eligibility test or eligibility check. So, check nila kung tutunay ba yung mga bid na to. Titignan nila kung fake ba. Ano mga kasi fake, hindi wala din. Next one, evaluate bids with the assistance of TWG, or Technical Working Group. So, ini-evaluate nila, inintindi nila maigi yung mga bids na yun. Kasi, syempre, kailangan intindihin niya para sa BAC organizational structure nila. And para sa mga ngayon ginagawa nila, kailangan nila maging reliable, syempre. Next one is they receive and open bid. Siyempre, kung papabid ka, siyempre, need mo to. And yun nga, isa sa mga responsibility ng BAC. Nire-receive and open bids nila. And the other one is resolve motion for reconsideration. Yung mga process na pwedeng reconsiderate, sila na rin yung nag-analyze ng mga yun. Hindi na nag-chat up. So marami po silang mga ginagawa or mga responsibilities and functions of this BAC, and hindi naman natin maisa-isa lahat yon. Siyempre, dahil sobrang dami mo. So let's further elaborate back organizational structure. So before proceeding, singit ko lang. So ano nga ba yung kahalagan ng bidding, di ba? So bidding, syempre, kapag nagbe-bid tayo, na lalo nating nadi-distinguish yung quality ng product or malalaman natin kung ano talagang binibili natin. And at a lower cost, syempre. Pipiliin pa rin natin makatipid. At a lower cost, nakakapag-bid tayo, nakakapag-buy tayo ng mga quality products na alam natin talagang quality talaga. So, proceeding to the topic. So, back organizational structure, TWG is created by BAC, of course, sabi na kanina, from a pool of technical, financial, and or legal experts. So, hindi lang daw putyo-putyo yung TWG or yung technical working group. Kinukuha siya sa pool ng technical, financial, and legal experts. So, mga expert talaga, yung mga may expertise about a certain position nga, with a specialty on a certain thing. So let's expand more the TWG with its responsibilities. Alamin natin yung mga responsibilities nila as created by BAC. So responsibilities of TWG, Technical Working Group. Number one, assist BAC in preparing bidding documents. Assist nila, tutulungan nila yung organization para sa mga documents para hindi na mahirapan. So, ito nga yung TWG nga yung let's say, number one helper nila. Kasi nga, technical working group. And sa mga technical, sila yung mga gumagawa. Number two, assist BAC again. Eligibility check. Number three, assist again, BAC in bid evaluation and preparation. So, sila nga yung magkasanggang dikit ng BAC organizational structure. Sila yung may halos pinakamahalagang ginagawa sa loob ng organization. And etc. So marami pang iba, marami pa silang ginagawa. And it's all about assisting the BAC sa mga ginagawa nila, yung organization sa mga ginagawa nila. Proceeding with the next branch, which is the Head of Procuring Entity, or the HOPE, or HOPE ba to? So, she must ensure that all procurements are in line with the APP. So, this in line with the APP or simply in-app or in APP is, ito yung an advanced way, mobile advertising for simultaneous auction or simultaneous bidding. So, pinuput siya or nilalagay siya sa auction para makapag-bid ng simultaneously yung mga bidders or yung mga buyers na gusto bumili ng product na yun. So, she must establish the BAC and the BAC Secretariat in accordance with the guidelines previously discussed. So, itong HOPE is yung nagsasabi or nag-establish sa BAC and BAC Secretariat ng mga gagawin nila and ng mga guidelines sa mga gagawin nilang bidding or gagawin nilang actions about that. So, that's it for the discussion of my part. So, thank you for listening and I hope you understand some information and hope you learn a lot.
Good morning, everyone. I'm Junvel Celestina, and for the continuation of the topic Republic Act 9184, I will be discussing Rule 2, Section 7, Procurement Planning and Budget Linkage. But first, what is procurement planning? Procurement planning is a process of identifying and consolidating requirements and determining the timeframes for their procurement with the aim of having them as and when they are required. The purpose of this is for the procuring entity to schedule the procurement activities in accordance with the approved budget and target date of implementation. Sa pamamagitan nito, maaaring malaman ang mga resources, kung saan ito makukuha at kung kailan ito kailangan. Mahalaga ang procurement planning lalo na sa mga infrastructure projects. Mas madali nitong matrack ang activities since scheduled na ito, which means kung sakali magkaroon ng mali sa project, malaman agad ito at masusolusyonan. Also, dinedetermine nito ahead of time ang budget na kakailanganin. Sa pamamagitan nito, may iwasan ng department ang overspending at pwedeng mabawasan ang expenses since part ng procurement planning ang product sourcing. According sa RA 9184 Rule 2, Section 7.1, all procurement shall be within the approved budget of the procuring entity and should be meticulously and judiciously planned by the procuring entity. Since nasa procurement planning ang budget proposal, once na i-approve ito, lahat ng procurement activities ay dapat hindi sasobra sa approved budget. Para sa mga infrastructure projects, dapat kino-consider ang estimated phasing ng related activities tulad ng topographic surveys, site investigation, and acquisition of right-of-way, preparation of plans, specifications, and other requirements. Pero ano nga ba ang approved budget? Ang approved budget ay ang proposed budget na aprobado ng head of procuring entity based sa annual procurement plan as consolidated from various project procurement management plans. For example, sa infrastructure project ng DPWH, ang approved budget for the contract must be composed ng estimated direct cost, including yung cost ng materials, labor, permits, and equipment expenses, plus estimated indirect costs na merong overhead, contingency, and miscellaneous expenses at contractor's profit margin. Mga factors din na kailangan i-consider sa pagdedetermine ng approved budget for the contract. Una ay ang market price na nagre-refer sa product or service cost, ang inflation factor since ang procurement planning is ahead sa actual procurement date, at ang cost of money para sa mga government agencies which usually nagbabayad in credit terms. So, to therefore conclude, bago magkaroon ng output ang projects ng DPWH, kailangan mo nang ilakad ang budget proposal sa DPM which usually happen upon issuance ng budget call around January. As soon ma-approve ang budget proposal na ito, plus the APP, ito na yung magiging guide for the coming year. According sa RA 9184, Rule 2, Section 7.2, no procurement shall be undertaken unless it is in accordance with the approved annual procurement plan, including approved changes thereto. The reason for this is kailangan maging consistent ng bawat department sa duly approved yearly budget na aprobado ng mga head of procuring entity. Annual procurement plan and project procurement management plan will be furthermore discussed by my groupmates.
Good morning, my name is Lowell Adriel T. Raffles and I'm here to discuss the procurement planning budget. In addition, it is a procurement plan for good infrastructure project and consulting services. Number 2 shall specific the type of contract to be employed, extent, size of contract, scope and packages, the procurement methods to be adopted, and indicating if the procurement task is to be outscored, time schedule for each procurement activity, and the estimated budget for each procurement. The preparation and updating of the PPMPS shall be the responsibility of respective project management offices, PMOS, or end user unit of the procuring entities. Based on IRRR Section 7 provided the legal reference for the preparation of the Project Procurement Plan or PPMP. Project Procurement Management Plan. A PPMP for particular contract deals primarily with number one, planning for the procurement of project requirements. Number two, procurement strategy. Number three is readiness of the procurement in terms of completion of detailed engineering in case of the infrastructure contract, completeness of binding documents and including invitations to bid, instructions to bidders, contract conditions, scope of work, specification, etc. In conclusion, in the DPWH budget, the availability of right-of-way is, if applicable, and number four is schedule of the procurement activities in an effort to obtain infrastructures and consulting service and goods for a contractor, consultant, and supplier. There are two types of project procurement management plan. Number one is the indicative PPMP prepared for purpose of formulating the DPWH budget proposal and consolidated into the indicative APP. Number two is the final PPMP revised and updated based on approved budget under the GAA and consolidated into the final APP. Annual Procurement Plan or APP should consider the following factors. The APP should include all procurement activities planned for the year. Number two is the APP shall include only those procurement that are considered crucial to be in efficient discharge of governmental function. Number three is the APP shall include the provisions of foreseeable emergencies based on historical records. Number four, it is paramount that project implementation timelines are met. In based on IRR Section 7 provided the legal reference of the preparation of the annual procure plan or also known as APP. There are two types of annual procurement plan. Number one is the indicative APP prepared for proposal of formulating the DPWH budget proposal for the succeeding calendar year for inclusion in the national pages 47 of 106 May 2016 guidelines of on the establishment of procurement system and organization in the DPWH expenditure program. Number two is the final APP revised and updated based on approved budget under the General Appropriations Act or GAA and approved by the HOPE. In preparing the APP, the BAC shall consider the following factors. Number one is the APP shall include all the procurement activities planned for the year. The approved APP shall be basis for the procurements of procuring entity and only those projects and procurements include therein shall be undertaken. Number two is the APP shall include the only those procurement that are considered crucial to the efficient discharge of the governmental function. The IRR considered the procurement crucial to be efficient discharge of governmental function if one is it is required for the day-to-day operations of procuring entity, or number two, it is pursuit of the principal mandate of the procuring entity. Number three is the excuse me, the APP shall include provisions for possible emergencies for good based on historical records. The BAC through the BAC Secretariat secretary shall include wherein the lump sum to cover these emergencies or contingencies which must not be more than 5% of the total appropriation of maintenance, operating, and other expenses of the procuring entity. For infrastructures, consulting services, the contingency shall be built into the ABC. Number four and last is scheduling the procurement activities shall be done in such a manner and that BAC and the other offices units in procuring entity involved the procurement process are available efficiently manage the conduct of procurement transactions. It is paramount that project implementation timelines are met. Procurement budgeting, planning, and budgeting. A review and updating of individual PPMPS and APP shall be done regularly at least once every 6 months or as often as necessary. Thank you.
So, procedure of procurement. So, ito yung procedural step of procurement by public bidding. So, yung first step ay pre-procurement conference. So, yung main purpose ng pre-procurement conference ay para malaman yung readiness ng bidding process. Mandatory ang pre-procurement conference sa mga goods na sa procurement ng goods na 2 million and above ang ABC or ang approved budget for the contract. After na pre-procurement conference ay advertising or posting ng invitation to bid. So dito, yung procuring entity siya yung mag-advertise ng ibibid o ng bidding. Tas be required na mag-advertise ng project pag below 2 million ang ABC or ang approved budget for the contract. Dapat rin 7 continuous calendar days na nakapost siya sa PhilGIPS website ng procuring entity at saka sa conspicuous space sa premises ng procuring entity. Next step ay issuing the bidding documents. So yung bidding documents, nandito lahat. Yung plans, specification ng project, requirements para sa mga bidders, at saka mga bid forms. So pag-issue ng bidding documents, may bayad siya. Ito yung standard rate. 500 pesos yung pinakamababa para siya sa 500,000 na project and below. And so on. Ayan na yung mga yon. Tapos, next step ay pre-bidding conference. So dito, i-explain ng procuring entity ang lahat ng gusto niya mangyari sa project. So dito yung clear discussion ng mga bidders at saka ng procuring entity tungkol sa project. Tapos mandatory ito sa project above 1 million yung approved budget for the contract. So yung pre-bidding conference ay nagaganap siya at least 12 days before ng submission ng envelopes o ng documents. So after ng pre-bidding conference, tatanggap na si procuring entity ng mga envelopes. So yung 2 envelopes na yon, yung first envelope, nandito yung eligibility or technical documents. So lahat ng hinihingi ng procuring entity, yung mga requirements, nandito nakalagay. Pati minsan dito rin nilalagay ng mga contractor yung mga project nila, yung mga natapos nilang project, dito rin nilalagay yun. Tapos, yung second envelope is yung financial information ng contractor. And dito, yung financial information ng company, tapos yung dito rin nakalagay yung kung magkano yung bidding price nila dun sa project. Tapos next step ay evaluation and rank bids. So dito, ini-evaluate nila yung mga documents na pinasa ng mga bidders at saka irarank yung bid from lowest to highest. Tapos yung next step ay submission of additional request. So dito, hihingi yung procuring entity ng additional request sa bidders kung meron. Pero kadalasan kasi hindi na nahingi kasi required na yun, nasa requirements na ng ano yun, ng bidding docs, nandun na lahat yun, pati requirements. Kaya minsan hindi na nahingi ng additional request. So next step ay post-qualify o qualification. So dito yung lowest calculated bid mag-undergo ng verification at saka validation kung nakapasa ba siya sa mga requirements at kung nasunod ba yung bidding documents. Tapos yung next step ay approve resolution and issue of notice of award. Dito, yung may pinaka-lowest calculated and responsive bidder ang makakuha ng contracts. So kung sino yung may pinakamababang bid, siya yung makakuha ng contract at saka responsive dapat yon. Tapos yung procuring entity, siya dapat yung mag-i-issue ng notice of award para ma-notify yung bidder. So yung next step ay yung prepare and sign contract. So dito magsasign na ng kontrata si procuring entity, ay si contractor. Yan, si contractor magsasign na siya ng contract. So yung last step naman ay issue notice to proceed. So dito, within 7 days, pagkatapos ng permahan ng kontrata, mag-i-issue na si procuring entity ng notice to proceed. So pag natanggap na ni contractor to, pwede na siya mag-start sa project.
Now let's move naman dun sa penal clause where we'll talk about the offenses and its corresponding penalties. Without prejudice to the provision of RA 3019, which is the Anti-Graft and Corruption Practices Act, and other penal laws, yung mga public officers or yung mga officers and employees of the government na gumawa ng offense, it is said that maaari silang makulong na minimum of 6 years and 1 day and maximum of 15 years. There are cases wherein some private individuals are involved in such acts and they should also be liable for the offense. In addition to that, once they were proven guilty, the public officer will be temporarily disqualified from public office, tapos yung private individual naman ay permanently disqualified from transacting business with the government. These penalties and offenses shall cover lahat ng types ng procurement, whether it's done manually or electronically. First in the list ng penal liabilities of a public officer is opening of sealed bids and documents na sinubmit electronically ahead dun sa mismong public opening. Itong mga sealed bids, usually ginagamit siya in bidding for government contracts. Unlike sa open bids na contractor can actively compete with each other and make multiple bids, dito naman they get only one chance. Di nila pwede i-adjust yung bids nila once nakapag-submit na sila. Sealed bids are usually nakalagay sa sealed envelope physically and are all to be opened at once during sub-opening ng bids. But in some cases na they're submitted electronically like through emails, the officers still cannot and shouldn't open it ahead of time. Next is delaying the screening, opening of bids, evaluation, and awarding of contracts without justifiable cause. The public opening of bids and proposals should take place immediately after ng deadline ng submission, unless yung delay is caused by events that are not within control ng body na responsible for awarding ng contract. Sa evaluation naman, sometimes yung panel ay hindi available because of their other commitments or yung schedule nila is not matched dun sa evaluation schedule. That's why importante din na i-ensure yung availability ng panel and their commitment sa evaluation schedule para ma-avoid yung delay sa awarding of contract. The officer should not intentionally delay any of the process for his own interest or for the sake of a particular bidder. As much as possible, hindi dapat na-delay yung buong process ng bidding. Next naman is influencing or pressuring any member of the BAC or any officer or employee of the procuring entity to make particular action that will be in favor of a particular bidder. BAC stands for Bids and Awards Committee. Part ng responsibility nila yung pagdedetermine ng eligible prospect bidders, pagre-receive ng bids, and pagkakonduct ng evaluation and recommending awards of contracts sa head ng procuring entity. Using your position to influence these people para mapanalo yung bidding by any means for the sake of a particular bidder is strictly prohibited by law. Next is splitting of contracts into smaller quantities and amounts or dividing contract implementation into subcontracts para ma-avoid yung competitive bidding or ma-evade yung requirements set by law. Although yung pagdidivide ng contract into phases does not automatically constitute splitting of contract as long as it's been done to attract maximum competition and carry out the process in an efficient and economic manner. But in doing so, it should be ensured na hindi siya ginagawa just to find a way around the law. Another offense is when the head of the procuring entity abuses power and i-reject yung ibang bids para sa bidder who is close or related to him ang ma-awardan ng contract. Dito papasok yung work ethics natin. At all times, we should be fair and work professionally. May ganitong cases kasi minsan, dito yung sinasabi nila na basta may kapit sa mga officials kasi magkakilala sila or acquainted, sila yung mas pinapaboran. In this law, they stated that doing this, the head should be given corresponding penalties. Kagaya nga ng sinabi ko kanina, there are cases wherein some private individuals are involved in such acts. The next ones will be the offenses na if nakamit ng private individual and any public officer involved, kagaya doon sa una, if they were proven guilty, makukulong sila for not less than 6 years to 15 years max. Karamihan sa offenses dito ay more on manipulating yung bidding para magkaroon yung bidder ng advantage against their competitors and siya makakuha ng contract. The first one is when two or more bidders bid and submit bids as the legit bidders with the knowledge na yung iba sa kanila ay may mas mataas na bid kaysa sa iba. In this way, magiging mas malaki yung chance na the one with pre-arranged lowest bid yung makakuha ng contract. Parang nagkasundo sila and pinlano nila na ganun yung gawin para makuha ng isa sa kanila yung project. Next is when a bidder submit different bids through other people or business entities para mapalabas na madaming bidders, pero ang totoo is siya lang talaga yon. Parang pinapalabas lang yan na merong competition para makapag-proceed and makuha niya yung contract. Next naman is when two or more bidders ay nagkasundo na mag-back out or i-withdraw yung na-submit na bids ng isa or ng iba sa kanila para ma-secure yung pagkapanalo ng isang bidder o kaya para magkaroon to ng advantage against sa mga ibang competitors. Another offense is when a bidder or bidders did some schemes para magkaroon ng advantage against other competitors. This includes paninira dun sa ibang parties or something na magkakakos para may advantages sila to the public compared to other bidders. Next naman is submitting eligibility requirements that contains false information or fake documents para makalusot sa eligibility screening process. Kasama dito yung pagko-conceal or pag-omit ng information na pwede maging reason para di sila maging eligible to participate sa bidding. Dito naman sa next ay parang kagaya lang ng previous one, pero sa bidding documents naman siya. It is done para ma-manipulate yung outcome ng public bidding and para sila yung makakuha ng contract. Next is participating in competitive bidding gamit yung pangalan ng ibang tao or pinagamit mo yung pangalan mo sa ibang tao para makasali sila sa bidding. There are some cases na for some reasons, one can't use their name for bidding kasi they are banned or blacklisted with the procuring entity from participating in the bidding of all government projects. Last is when the bidder withdraws their bid once it's qualified as the lowest calculated or highest rated bid, or the bidder refused to accept an award without any acceptable reason, or para ibigay ng procuring entity yung contract sa ibang bidder. Kasama dito yung hindi pag-submit or pagde-delay ng submission ng requirements. When you're charged guilty of any of these offenses, you will be given the respective penalty. And pag napatunayan na may public officer na involved, especially dun sa first four sa list, they will be temporarily or permanently disqualified from public office. This applies to all procurement types kahit na it's done manually or electronically. And if ever the bidder who commit offense is a judicial entity like organization and such, yung criminal liabilities and penalties ay ibibigay dun sa director, officer, or employee na gumawa mismo ng act na yun. If ever a person liable or found guilty has a controlling interest in a prospective bidder entry, yung entry nila will be disqualified to participate in any procurement activity ng government. The official power to make legal decisions and judgments regarding sa mga offenses belongs to the appropriate courts and should be according to existing laws. At that time, the court will be the one to charge someone guilty or innocent of such criminal liabilities.
So, yun na yung sa ano sa group niyo.
Opo, sir.
So, yun. So, thank you sa group. So, mali pala yung na-type ko dun sa assignment na RA 9185 pala yung na-type ko. Buti naman at tama yun na ano nyo. So, thank you dun sa group 1. Siguro i-send na lang sa akin yung file nung reporting, yung video, yung dalawa. I-upload nyo na lang tapos pa-send na lang sa akin. And then, since ayan, saktong-sakto naman, start naman, pahinga lang, exactly 9:30 naman mag-start yung group 2. So, yung re-report naman nila is yung some extracts from the new civil code para sa obligations and contracts. So, ayan, buksan ulit natin yung mga webcam natin para sa attendance. So, ayan. Yung iba, yung iba. Yung iba pa, at least majority. Sige, yan na yan. So, ayan. Okay, 1, 2, 3, smile. Ayun, so okay na, thank you. Doon sa natitirang 2 minutes. Siguro ano na lang din. Isang mabilis na na quiz. Yes, nga, sige mag-evaluate muna para mamaya na lang yung quiz. Sige, pa-evaluate muna dun sa link na nasa chat. For the next group, you may proceed na kung ready na kayo.
I'm James Daryl Eforiano, and I'm here to discuss the extracts from the new Civil Code and Obligation and Contracts, and the first two chapters of it. So let's get started. So we will talk about the Chapter 1, General Provision. In this chapter, we have Article 1156 down to 1162. So let's start with Article 1156. So what is this article? Article 1156 talks about the definition of obligation. So what is the definition of obligation? A judicial necessity to give, to do, or not to do, or simply means judicial necessity because non-compliance can result in judicial or legal sanction. Also, we have the elements of obligation. What are those? We have the active subject or the creditor. We have the passive subject, obligor or debtor, and the object of presentation, the subject matter of the obligation, and the efficient cause, the reason why the obligation exists. This Article 1157, sources of obligation, talks about the primary sources of obligation such as law, contracts, quasi-contracts, acts of omission punishable by law or delicts, quasi-delicts or torts. So the next article, Article 1158, obligation derived from the law. So as we said earlier, we have the sources of obligation and law is one of it. So in this article, we will talk about the law. So obligation derived from the law are not presumed, only those expressly determined in this code or in special laws, regulated by the precepts of the law which establish them. And the next article, Article 1159, an obligation arising from contracts. So have the force of law between the parties, and meaning that neither party may unilaterally and upon his own exclusive volition escape his obligation under the contract, unless the other parties assented therefore, or unless for causes sufficient in law and pronounced adequate by competent tribunal. So should be complied with a good faith, and also compliance in good faith means that we must interpret not by letter that kill, but the spirit that give life. So Article 1160, obligation derived from quasi-contract. Quasi-contract also means the extra contractual obligation. So the definition of it is that the judicial relation resulting from a lawful, voluntarily, and unilateral act in which has for its purpose the payment of indemnity to the end, that no one shall be unjustly enriched or benefited at the expense of another. We have negotiable gesture or unauthorized management, and the solution indemnity or indue payment for this article. And the next article, obligation derived from ex dedico or ex maleficio. As we said earlier, this is the obligation that talks about the acts of omission punishable by the law. And obligation originating from wrongful conduct against the person or property of another. It is an obligation enforceable in the law. So for the last article, Article 1162, obligation derived from ex quasi delicts or ex quasi malefico. It is a fault or act of negligence or omission of care which cause damage to another. There is no pre-existing contractual relation between the parties. So chapter 2, nature and effects of obligation. As well as the chapter 1, chapter 2 have a tons of article from article 1163 down to 1178. So let's start with the first article, article 1163. So this talks about the obligation of every person to take care of determinate specific thing with proper diligence of a good father of a family. So it says that each of us, each person, each individual should take care of a specific thing, just like a good father of a family, with proper diligence. Article 1164. The creditor has the rights to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. Article 1165, delay, or in this article means legal delay or default. So we have two kinds of delay, the ordinary delay, cause of negligence, and the legal delay. How can we say that is the legal delay? We can say if there was a judicial or extrajudicial fulfillment in causing the delay. Article 1166, it only talks about the accessories and accession. So what are those? Accessories, those joined or included in the principal for perfection or enjoyment, just like keys to a house or jack of a car. While the accessions, addition to improve upon a thing, just like whatever we build upon the land or the parcel of land, we can call it accessions. So Article 1167, the obligation to do. If the creditor or debtor fails to do something, the creditor can have the obligation performed by himself or another at the debtor's expense. Article 1168, when the obligation consists in not doing, and the obligor does what has been forbidden him, it shall also be undone at his expenses. Article 1169, those obliged to deliver or to do something incur in the delay from the time the obligee judicially or extrajudicially demands from them the full payment of their obligation. Article 1170, those who are in performance of their obligation are guilty of fraud, negligence, or delay, and those who are in the manner of contravene and tenor, therefore, are liable for the damage. For the Article 1171, responsibility arising from fraud is demandable in all obligation. Any waiver of an action for future fraud is void. And the Article 1172, responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by courts according to the circumstances. Chapter 2, Article 1173. The fault or negligence of the obligor consists in the omission of the diligence which is required by the nature of obligation and corresponds with the circumstances of the person, of the time, and the place. Article 1174, fortuitous event. Event which could not be foreseen or which through foreseen were inevitable. Article 1175, serious transactions shall be governed by special laws. Usury, contracting, or receiving something in excess of amount allowed by the law for the loan or use of money, goods, chattels, or credit. And the Article 1176, presumptions on receipt of the principal or the latter installment. These are disputable presumptions, and evidence may be introduced to the contrary by the creditor. Article 1177, remedies of creditor to enforce payment of his claims against the debtor, and the final article, Article 1178, rule of transmissibility of rights and exceptions thereto.
Good morning, everyone. I'm MC, reporting Chapter 3, Section 1 and 2. Chapter 3, Different Kinds of Obligations. Section 1, Pure and Conditional Obligation. Pure obligation, ito yung obligation na hindi subject sa anumang kondisyon at wala siyang specific date para bayaran pero demandable siya. While ang conditional obligation naman ay susundin mo yung obligasyon
na may kondisyon. Article 1179. Every obligation whose performance does not depend upon a future or uncertain event or upon a past event unknown to the parties is demandable at once. Every obligation which contains a resolutory condition shall also be demandable, without prejudice to the effects of the happening of the event. Tinutukoy sa article na ito ay pure obligation. Sinasabi dito na ang pagbabayad ng utang ay hindi nakadepende sa past, future, or uncertain events na hindi alam ng kabilang party. Ibig sabihin ay pwede kaagad i-demand or hingiin ang utang. Article 1180. When a debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be one with a period, subject to the provisions of Article 1197. Sinasabi sa article na ito na hindi dapat gawing kondisyon ng may utang ang pagbabayad ng utang kung kailan lang nagustuhin. Dapat may nakatakdang panahon na ibigay ang magpapautang na naaayon sa Article 1197 para hindi magkaroon ng problema. Article 1182. When the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon chance or upon the will of a third person, the obligation shall take effect in conformity with the provisions of this code. Sinasabi sa article na ito na kung ang pag-fulfill ng isang kondisyon ay nakadepende lang sa nagkakautang, ang conditional obligation ay walang bisa. Pag nakadepende naman ito sa kagustuhan ng third person, magkaka-effect ang obligation na naaayon sa provision ng code na ito. Article 1184. The condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires or if it has become indubitable that the event will not take place. Article 1185. The condition that some event will not happen at a determinate time shall render the obligation effective from the moment that the time indicated has elapsed, or if it has become evident that the event cannot occur. If no time has been fixed, the condition shall be deemed fulfilled as such time as may have probably been contemplated, bearing in mind the nature of the obligation. Sinasabi sa Article 1184 at 1185 na kapag hindi na-fulfill ng may utang, nabayaran ng utang niya sa nakatakdang panahon, ay magkakaroon ng bisa ang obligation upang mabayaran niya ang utang. Kapag naman na-fulfill or nabayaran na ng may utang, ang kanyang utang ay mawawalan na ng bisa ang obligasyon dahil natapos niya na ito. Kung sakaling walang panahon ay tinakda, ang kondisyon ay pwede nang ituring na natupad sa panahong maaaring napagnilayan at isinaalang-alang ang katangian ng obligasyon. Article 1192. In case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished, and each shall bear his own damages. Sa pagkakataong both parties ay nag-breach ng obligation, ang pananagutan ng naunang panig na nagkamali ay maaaring paghahanin ng korte sa patas na pamamaraan. Kapag hindi matukoy kung sino ang naunang nagkamali, ang kasunduan ang ipapawalang bisa at ang bawat panig ang mananagot sa kanilang sariling pinsala. Section 2. Obligation with a period. Obligation with a period is that neither the obligee may demand performance nor obliger perform his obligation before the arrival of the period agreed upon for the period in so constituted for the benefit of the two parties to the obligation. Ang obligation with a period ay sinasabi na hindi pwedeng maningil ang nagpapautang habang hindi pa due date at hindi din pwede magbayad ang nangutang ng maaga. Sinasabi na ginawa ito dahil ang napagkasundo ang due date ay pabor parehas at magbibigay ng benepisyo sa dalawang panig. Article 1193. Obligations for whose fulfillment a day certain has been fixed shall be demandable only when that day comes. Obligations with a resolutory period take effect at once, but terminate upon arrival of the day certain. A day certain is understood to be that which must necessarily come, although it may not be known when. The uncertainty consists in whether the day will come or not. The obligation is conditional, and it shall be regulated by the rules of the preceding section. Maaari lamang ipatupad ang pag-oobliga kapag dumating na yung araw ng itinakda o pagdating ng day certain. Ang day certain ay sinasabi na balang araw ay darating pero hindi alam kung kailan. Ito ay ang araw ng kamatayan. Ang mga obligasyon na may resolutory period ay magkakabisa agad pero matatapos o mataterminate ito sa pagdating ng day certain. Kung may pag-aalinlangan sa pagdating ng day certain, ang obligasyon ay kondisyonal at ito ay pinapatakbo ng patakaran ng nakalipas na seksyon. Article 1194. In case of loss, deterioration, or improvement of the thing before the arrival of the day certain, the rules in Article 1189 shall be observed. Article 1195. Anything paid or delivered before the arrival of the period, the obliger being unaware of the period or believing that the obligation has become due and demandable may be recovered with the fruits and interest. Article 1196. Whenever in an obligation a period is designated, it is presumed to have been established for the benefit of both the creditor and the debtor. Unless from the tenor of the same or other circumstances, it should appear that the period has been established in favor of one or of the other. Dito sa article na ito, sinasabi na tuwing ang obligasyon ay binibigyan na ng due date, sinasabi na ginawa ito para mag-benefit ang parehas na partido, ang nagpapautang at nangungutang. Maliban na lamang kung ang ibinigay na due date ay mas pabor sa isang panig. Article 1197. The obligation does not fix a period, but from its nature and the circumstances it can be inferred that a period was intended, the court may fix the duration thereof. The court shall also fix the duration of the period when it depends upon the will of the debtor. Sinasabi sa article na to na kapag ang obligasyon ay hindi nagtatakda ng due date, ngunit sa uri at kalagayan ay may ipapalagay na ang panahon ay nakatakda na, ang korte ay maaaring magtakda ng hangganan nito. Ang korte ay magtatakda rin ng panahon o hangganan kapag ito ay nakasalalay sa kalooban ng may utang. Sa bawat obligasyon kung saan ang bawat partido sa mga pagkakataon ay marahil na pag-iisipan ang pagtatalaga ng hangganan o panahon. Ang korte ang magtatalaga ng panahon o hangganan ng pagbabayad ng obligasyon. Ang hangganan o panahon ay tinalaga ng korte ay hindi na maaari pang baguhin.
Good day, everyone. I am Shaina Sauli, and I'm going to discuss about Chapter 3, Section 3 and 4, which is the alternative obligation. In here, it says that debtor is alternatively bound with various prestations that are due, but the performance of one of them is sufficient to extinguish the obligation. In Article 1199, a person alternatively bound by different prestations shall completely perform one of them. For example, John borrowed 50,000 cash from Sheena, and it was agreed that John has the alternative to pay either iPhone 16 Plus or 50-inch LED TV. Next, in Article 1200, it says that the right of choice belongs to the debtor unless it has been expressly granted to the creditor. The debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of obligation. In Article 1201, the choice shall produce no effect except in the time it has been communicated. The notice of selection or choice of prestation may be communicated in writing, verbally, impliedly, or by any other unequivocal means. In Article 1202, the debtor shall lose the right of choice when among the prestations whereby he is alternatively bound, only one is practicable. When all of the prestations except one have become impossible or unlawful, the debtor loses his right of choice. This is because the obligation loses its alternative character. It becomes a simple obligation. In Article 1203, if through the creditor's acts the debtor cannot make a choice according to the terms of the obligation, the latter may rescind the contract with damages. On this article, the debtor may rescind the contract with damages if he could not make any choice in accordance with the terms of the obligation due to the creditor's fault. Due to the creditor's fault. due to the cred- due to the creditor due to the creditor's fault. Next, in Article 1204, the creditor shall have a right to indemnity for damages when, through the fault of the debtor, all of things which are alternatively the object of the obligation have been lost, or the compliance of the obligation has become impossible. The indemnity shall be fixed, taking as a basis the value of the last thing which is appeared, or that of the service which must become impossible. Damages other than the value of the last thing or service may also be awarded. If the impossibility is caused by the fault of the debtor, the law is clear. The creditor is entitled to indemnity for damages. In Article 1205, when the choice has been expressly given to the creditor, the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. Until then, the responsibility of the debtor shall be covered by the following rules. First, if none of the things is lost through a tortious event, he shall perform the obligation by delivering that which the creditor should choose from among the remainder, or what which remains if only one subsists. Next, in Article 1206, when only one prestation has been agreed upon, but the obligor may render another in substitution, the obligation is called facultative. The loss or deterioration of a thing intended as substitute through the negligence of the obligor does not render him liable. But once the substitution has been made, the obligor is liable for the loss of the substitute on account of his delay, negligence, or fraud. For example, yung alternative na ibabayad mo ay pagdating ng panahon biglang bumaba ang kalidad, hindi siya parang nag-ipon na debtor or no. In Article 1207, the concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand or that each one of the latter is bound to render enter compliance with the prestation. There is a solidary liability only when the obligation expressly so states, or when the law or the nature of the obligation requires solidarity. Sinasabi kapag ang isa o higit pa na utang o ang isa o higit pa na umutang sa isa ay may parehong karapatan or may parehong pananagutan, ngunit hindi nangangahulugan na bawat isa ay may karapatang manigil. In Article 1208, from the law or the nature or the wording of the obligations to which the preceding article refers, the contrary does not appear, the credit or debt shall be pursued to be divided into as many equal shares as there are creditors or debtors, that the credits or debts being considered distinct from one another, subject to the rules of court governing the municipality lawsuits. Next, in Article 1209, if the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter shall be insolvent, the others shall not be liable for his share. In this article, it applies to joint indivisible obligation because the prestation or object is not susceptible of division, and solidarity is not provided. In Article 1210, the indivisibility of an obligation does not necessarily give rise to solidarity. Ang pagiging hindi nahati ng obligasyon ay hindi ibig sabihin na may solidaryo yung obligasyon, hindi rin ito ibig sabihin kung may solidaryo yung obligasyon ay mayroon ding hindi paghahati ng obligasyon. In Article 1211, solidarity may exist, although the creditors and debtors may not be bound in the same manner and by the same period and conditions. In Article 1212, each one of the solidary creditors may do whatever may be pleasing to others, but not anything which may be prejudicial to the latter. A relationship of mutual agency exists by solidarity with the creditors. The act of one will affect the others because of their relationship. Solidarity with the creditors may perform acts which are useful or beneficial to debtors. Every solidary creditor is verified by the useful acts of one. If a solidary creditor performs an act which is prejudicial to his co-creditor, the act may have a valid legal effects, but the performing creditor shall be liable to his co-creditors.
Good day, I am Nika Clarice B. Lamras and I'm going to discuss Chapter 3, Section 5, Divisible and Indivisible Obligations. Divisible is an obligation that is capable of partial performance. For example, to deliver 50 cubics of bigger sand. Sa indivisible naman, obligation that is not capable of partial performance. For example, to deliver a specific car. Next, Article 1223, the divisibility of the indivisibility of the things that are the object of obligations in which there is only one debtor and only one creditor does not alter or modify the provisions of Chapter 2 of this title. Example, Max agreed to pay Jane 1,000 pesos in 4 equal monthly installments. The obligation of Max is divisible kasi capable of partial performance. Katulad ng ginawa niya, equal monthly installments. So, considered divisible siya. Paano naman kapag Max will pay Jane on December 25 the full amount of 1,000? Ang obligation dito ni Max is invisible kahit na yung money can be physically divisible, pero the intention of the party is that the obligation must be fulfilled at one time. Kaya considered siya na indivisible. Next, Article 1224. A joint indivisible obligation give rise to indemnity for damages from time any one of the debtors does not comply with his undertaking. The debtors who may have been ready to fulfill their promises shall not contribute to the indemnity beyond the corresponding portion of the price of the thing or the value of the service in which the obligation consists. So dito, pag sinabing joint indivisible obligation, ang object of obligation is indivisible and the parties are merely bound jointly. And para ma-achieve tong goal, obligation na to, there should be a common desire of all the joint debtors para mag-perform yung obligations. And if hindi nag-comply yung isa na gawin, ang mangyayari dito ay, according to the Civil Code, mako-convert daw, kasi nakalagay, effect of non-compliance, the obligation is converted to indemnity for damages. So, yung mga comply sa obligation ay hindi magko-contribute sa indemnity and beyond the corresponding portion of the price or the thing or the value of the service in which the obligation consists. Next, Article 1225. For the purpose of the preceding articles, obligations to give definite and those which are not susceptible of partial performance shall be deemed to be indivisible. So dito sa Article 1225, it talks about the rule and to determine the divisibility and the indivisibility. In obligation na to do, divisibility or indivisibility shall be determined by the character of the prestation in each particular case. Yung prestation daw, ang ibig sabihin ay the conduct to be observed by the debtor towards the creditor. So, paano malalaman kung indivisible obligation? A, obligations to give definite things. Yan, kailangan specific. Katulad kanina, ang example ng indivisible is to deliver a specific car. So letter B, those which are not susceptible of partial performance. Letter B, those which are not susceptible of partial performance. C, even if the thing is physically divisible, it may be indivisible if so provided by law. For example po, yung tax payment dito, meron tayong certain period of time para mabayaran yung payment. Yeah. Letter D, even if the thing is physically divisible, it may be indivisible if such was the intention of the parties concerned. Yung katulad na kanina, yung sa 1,000, kahit na physically divisible yung pera, pero ang intention ng party ay mabayaran ng buo na one-time payment lang. So, considered indivisible siya. So, paano naman malalaman kapag indivisible? Paano naman malalaman kapag divisible ang obligation? Letter A, when the object of the obligation is the execution of certain number of days of works. Yan, sa mga, pag nag-hire ng labor, kailangan matapos 10 days, gano'n. Letter B, when the object of the obligation is the accomplishment of work by metric units, kunwari, nag-hire ka, pinasukat mo, yung, gagawa ka ng bakal, yan, pwede yan, kunwari, 5 meter by 3 meter, gano'n. When object Letter C, when the purpose of the obligation is to pay a certain amount in installment. Yan, commonly yung sa mga utang, pwedeng gawing installment. And letter D, when the object of the obligation is the accomplishment of work susceptible of partial performance. Now, let's discuss Section 6, obligation with a penal clause. Article 1226. In obligation with the penal clause, the penalty shall substitute the indemnity for damages and the payment of interest in case of non-compliance. If there is no stipulation to the contrary, nevertheless, damages shall be paid if the obligor refuses to pay the penalty or is guilty of fraud in the fulfillment of the obligation. It states that there is a greater liability in case na may breach of contract. So, bakit nga ba mahalaga ang penal clause? This to ensure the performance of the obligation and to substitute for damages and the payment of interest if hindi na-comply sa obligation. So dito, sa Article 1226, kung saan kahit nag-demand ka ng penalty, pwede ka pa rin mag-demand ng damages and interest. May mga condition dito. Yung isa, pag nag-express ng stipulation, and pangalawa, kapag si debtor ay refuse na magbayad ng penalty, yan, pwede mag-start ng legal interest dyan. Then, yung guilty of fraud, yan, kailangan may pakitang proof of fraud or claim ng damages if magkano ba talaga yung damages. Article 1227, the debtor cannot exempt himself from the performance of the obligation by paying the penalty, save in the case where this right has been expressly reserved for him. Neither can the creditor demand the fulfillment of the obligation and the satisfaction of the penalty at the same time, unless this right has been clearly granted to him. However, if after the creditor has decided to require the fulfillment of the obligation, the performance thereof should be impossible without his fault, the penalty may be enforced. So dito sa Article 1227, pinapakita dito na penalty is not a substitute for a performance of obligation. So if si debtor ay nag-refuse na gawin ang obligation niya kay creditor, hindi siya pwedeng magbayad na lamang ng penalty para makaiwas siya sa obligation niya. Ganon din naman kay creditor. So, neither can the creditor demand the fulfillment of the obligation and the satisfaction of the penalty at the same time unless this right has been clearly granted on him. Si creditor naman, hindi naman din siya pwede mag-demand kay debtor na gagawin niya na nga yung obligation niya tapos may penalty pa siya. Unless kung napagkasunduan din katulad nung unang condition. Then, however, if after the creditor has decided to require the fulfillment of the obligation, the performance thereof should become impossible without his fault, the penalty may be enforced. So, dito naman, if si creditor, nag-demand naman siya na ipagpatuloy yung, or ipagpatuloy yung obligation, gawin yung obligation, pero dahil imposible na nga kay debtor na ipagpatuloy ito, pwedeng mag-ask si creditor ng penalty, payment for penalty. Proof of actual damages suffered by the creditor is not necessary in order that the penalty may be demanded. Sa Article 28, hindi na daw kailangan mag-provide ni creditor ng violation just to prove na merong na-violate si debtor. Basta may violation ng obligation, pwede na siya mag-demand ng penalty. Article 1229, the judge shall equitably reduce the penalty when the principal obligation has been partly or irregularly complied with by the debtor. Even if there has been no performance, the penalty may also be reduced by the courts if it is inquisious or unconscionable. So dito sa Article 1229, about naman sa pagpapababa ng penalty. Kahit na partly na nagawa niya yung performance or irregularly or no performance at all, at kung yung penalty is unreasonable, it depends on the compliance of the debtor kung paano niya pinerform yung obligation. 1230, the nullity of the penal clause does not carry with it that of the principal obligation. Meaning, if the principal obligation is void, penal clause is void. But if the penal clause is void, then the principal remains valid.
My topic is Chapter 4, Extinguishment of Obligation, Section 1. Article 1231, dito lang yung kung paano mawala yung obligation mo bilang isang debtor. Una, by payment or performance Pangalawa, by the loss of the thing due. Pangatlo, by the condonation or remission of the debt, or by the confusion or merger of the rights of creditor and debtor. 5, by compensation. 6, by novation. Itong mga nasabi ko is matatakil siya next. Article 1232. Ibig sabihin lang naman nito is yung payment daw, hindi lang siya bumibase sa money, kundi sa obligation mo as debtor or yung performance mo. The Article 1233, if you paid incomplete, then your debt shall not be erased. Kailangan bayaran pa rin ng buo ni debtor para maklear yung obligation mo. Sa Article 1234, if the obligation is nasa good faith, then yung damages is less lang kay obliged. Sa Article 1235, ang ibig sabihin lang neto is kahit na may mga irregularity sa payment, basta inaccept pa rin ni creditor nang walang complaint, then yung obligation is fully complied or extinguished na. Sa Article 1236, pwedeng hindi i-accept ni creditor ang payment ni third person. Depende na lang kung may stipulations or agreements between the two. Kapag walang consent si debtor or knowledge, mare-reimburse lang o yung binayaran lang ni third person ang kailangan bayaran ni debtor. Sa Article 1237, kapag ang ibang tao ang nagbayad kay debtor nang walang knowledge niya, then yung nagbayad ay hindi niya pwedeng i-compel si creditor or i-subrogate siya. Article 1238. Kapag si third person ay hindi pinagbayad si debtor, then it is called the donation. Tsaka this is valid pag inaccept ni creditor as payment. Sa Article 1239, ang ibig sabihin lang nito, mapapawalang bisa yung pagbabayad kapag ang isang tao ay walang kalayaan sa pagbabayad, tsaka pwedeng ilipat yung pagmamayari. Sa Article 1240, ang ano lang dito is, yung pagbabayad, pwede siyang gawin kung kahit kanino, basta pinahihintulutan lang ni creditor. Article 1241. Payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered, or insofar as the payment has been beneficial to him. Payment made to a person shall also be valid insofar as it has redounded to the benefit of the creditor. Such benefit to the creditor need not to be proved in the following cases. Number 1, if after the payment, the third person acquired the creditor's right. 2, the creditor ratifies the payment to the third person. 3, if by creditor's conduct, the debtor has been led to believe that the third person had the authority. Ibig sabihin nito, kapag nagbayad ka sa isang incapacitated person at kanya itong tinanggap, then your obligation will be extinguished. Sa Article 1242, kapag ikaw ay nagbayad sa isang trusted or pinagkakatiwalaan ni creditor, then yung utang mo or yung obligation mo is ma-void na or mawawala na. Article 1243, kapag ikaw na debtor ay nangutang sa iba para may ipangbayad kay creditor, then yung ibabayad mo is hindi magiging valid. Tsaka yung utang mo is mare-retain. Article 1244. Si debtor, hindi niya pwedeng i-force si creditor na i-receive or tanggapin yung kanyang binigay dahil hindi ito napag-usapan. Article 1245. Ang ibig sabihin lang neto, yung property mo ang ipangbabayad kay creditor. Article 1246. Ibig sabihin neto, kung ikaw ay magbibigay lang ng generic thing, then si creditor, hindi siya pwedeng mag-demand ng high quality. Ganun ka rin. Hindi ka rin pwedeng mag-demand ng magbigay ng inferior quality. Article 1247, ibig sabihin nito, si debtor daw po yung mag-shoulder ng extrajudicial expenses dahil siya rin naman po yung magbe-benefit nito. Unless, kung may stipulation po na mangyayari, then yung stipulation po shall be followed. Article 1248. Sabihin nito, di pwede magbayad ng kulang si debtor, tsaka si creditor naman is hindi niya pwedeng pagwawalan o i-require si debtor na magbayad ng dibo. Article 1249. The payment of the debts in money shall be made in the currency stipulated, and if it is possible to deliver such currency, then in the currency which is legal tender in the Philippines. Ibig sabihin nito, kung ano lang yung napag-usapang currency as a mode of payment, then yun lang yung pwedeng gawin. If it is not possible, you can use legal tender in the Philippines. For example, may 1 peso, 10 peso, and 5 peso coin ka. Pwede mo siyang ipangbayad pero hindi dapat siya lalagpas ng 1,000 pesos dahil abuso na. Next, the delivery of promissory notes payable to order or bills of exchange or other mercantile documents shall produce the effect of payment only when they have been cashed or when through the fault of the creditor they have been impaired. In the meantime, the action derived from the original obligation shall be in abeyance. Ibig sabihin nito, si creditor pwede niyang hindi accept yung payments kapag kunyari through promissory notes, bills of exchange or other mercantile documents. Article 1250. Ibig sabihin lang nito, kapag ang inflation or deflation ay bigla ang nangyari, then kung ano lang yung napag-usapan nyo between the two of you, then yun lang yung magiging basis of payment. Article 1251. Sinasabi lang dito yung place where the obligations shall be paid. Ibig sabihin dito, kung saang lugar ka nagbayad, then dapat dun ka rin lugar yung pupuntahan mo. And kung may stipulation naman na nangyari or condition or agreement, then dun sa napag-usapan nyo yung magiging place ng bayaran. Tapos, kunyari, si creditor ay lumipat naman ng ibang bahay, then siya naman yung mag-shoulder ng mga expenses. Mga ganun. Article 1252. He who has various debts of the same kind in favor of one and the same creditor may declare at the time of making the payment to which of them the same must be applied, unless the parties so stipulate or when the application of payment is made by the party for whose benefit the term has been constituted. If the debtor accepts from the creditor a receipt in which an application of the payment is made, the former cannot complain of the same unless there is cause for invalidation of the contract. Article 1253. Ibig sabihin lang nito is pwedeng hindi tanggapin ni creditor yung payment ni debtor kung hindi kasama yung interest or tubo dahil gusto niya may kikitain siya. Article 1254. When the payment cannot be applied in accordance with the preceding rules or if application cannot be inferred from other circumstances, the debt which is most onerous to the debtor among those due shall be deemed to have been satisfied. If the debts due are at the same nature and burden, the payment shall be applied to all of them proportionally. Ibig sabihin lang dito, kapag nagbayad ka sa isa, dapat kailangan magbayad ka rin sa kabila para fair. Article 1255. Ang ibig sabihin lang naman na itong Article 1255 is pwedeng i-give up ni debtor yung kanyang properties kay creditor and si creditor is pwede niyang ibenta at yun yung gawing ipambayad ni debtor.
Good day, I'm Justin John G. Peñafiel and I will report the subsection 3, Tender of Payment and Consignation. So subsection 3, Tender of Payment and Consignation. So ano ba ang Tender of Payment? Tender of Payment is the act on the part of the debtor of offering to the creditor the thing or amount due. The act of depositing the thing or amount due with the proper court naman ay yung consignation. So, ano ba ang mga articles under nito? So, una, Article 1256. If the creditor to whom tender of payment has been made refuses without just cause to accept it, the debtor shall be released from responsibility by the consignation of the thing or sum due. So, ang simple explanation lang nito ay by way of consigning, ang debtor ay nare-release na sa kanyang obligation. So, sabi din dito, consignation alone shall produce the same effect in the following cases. So, when the creditor is absent, when he is incapacitated, when or without just cause he refuses to give a receipt, when two or more persons claim the same right to collect, at lastly, when the title of the obligation has been lost. So, sunod naman, Article 1257. In order that the consignation of the thing due may release the obliger, it must first be announced to the persons interested in the fulfillment. So, ang sinasabi lang dito, dapat alam ng mga parties involved na may consignation na gustong gawin si debtor. So, Article 1258 naman ay consignation shall be made by depositing the things due at the disposal of judicial authority, before whom the tender of payment shall be proved in a proper case, and the announcement of consignation in other cases. The consignation having been made, the interested parties shall also be notified thereof. So, yun nga, kailangan i-notify yung mga interested parties at dapat may court na namamagitan dito i-deposit yung consignation ni debtor. At dapat may patunay din na siya ay nagkaroon ng tender of payment. Dapat yun ay ma-prove. So, Article 1259 naman, ang sinasabi lang dito ay kapag properly made yung consignation ay pwede nang si creditor ang sumalon ng mga bayarin na nangyari sa consignation, yung mga ginawa ni debtor. At sa Article 1260 naman, sinasabi na si debtor kapag tapos ng consignation ay pwede nang humiling sa judge na kanselahin ang kanyang obligation. At sabi din dito ay pagka hindi pa na-accept yung consignation or kapag hindi pa na tatanggap ng judge yung consignation ay pwede pang withdrawin ni debtor ang binayad niya or yung itinatago niyang bagay. Ang sabi naman sa Article 1261 ay kapag tapos naman na yung consignation at gusto ni debtor na withdrawin yung pera niya, kailangan niya magkaroon ng authorization galing kay creditor. At si creditor naman ay kailangan niya ng i-release yung mga kanyang ibang parties na involved, yung mga co-debtor, guarantors, and sureties. So, Section 2, Loss of the Thing Due. So, yung Article 1262, ang sinasabi niya ay yung obligation which consists in the delivery of the determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor and before he has incurred in delay. So, magkakaroon lang na fault dito yung debtor which is yung nagde-deliver. Kapag meron silang usapan ni creditor na kapag nawala, kahit na 42 event pa yan, ay meron pa rin liability si debtor. So, Article 1263 naman ay, ang sinasabi niya lang ay yung loss of generic thing. So, dahil generic nga, meron pa rin liability si debtor dun sa nawalang bagay kasi madali niya lang ulit yung mahahanap kasi yun nga ay generic thing. Article 1264 naman, ang sinasabi niya ay yung partial loss of the object of the obligation is so important as to extinguish the obligation. So kahit meron partial lang na nawala, hindi siya buong nawala, at yung nawala ay sobrang importante, pwede na ding ma-extinguish yung obligation dahil hindi na mag-work yung product or kaya yung document pag nawala yung isang part na yun. So, Article 1265 naman, ang sabi ay, whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault. Unless daw na mapatunayan ito ng debtor at hindi rin nag-apply yung pagpe-presume na ito kapag merong natural calamities like earthquake, flood, and storm. And 1266 naman, ang sabi ay, the debtor in obligations to do shall also be released when the prestation becomes legally or physically impossible. So kapag hindi na legally at physically possible, wala nang fault yung obligor. So Article 1267 naman, when the service has been so difficult as to manifestly beyond the contemplation of parties. So hindi na ma-handle ng both parties na involved. So yung obligor ay mawawala na ng obligation. So Article 1268 naman, when the death of a thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, pati yung pagkawala. So pagka due daw sa criminal offense, ang pagkakawala, liable pa rin yung si debtor dahil nga ito ay criminal offense. At lastly, Article 1269, the obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may be against a third persons. So dahil si creditor na sumalo nung responsibility ni debtor, pwedeng siya na ang mag-proceed na makipag-usap dun sa third person na kasali dun sa pagkawala. So, Section 3, Condonation or Remission of the Debt. So, itong section na to ay more on condonation, which is ang ibig sabihin ay yung dinonate na ni creditor kay debtor yung dapat na ibabayad ni debtor or hindi niya na tinanggap yung bayad. So, dito sa 1217, yung sinasabi na yung remission is essentially gratuitous and requires the acceptance by the obligor. So, Article 1271, dito naman sinasabi na merong naging kasunduan dun sa pag-deliver ng private document. So, dahil dineliver nga yung private document, ibig sabihin ay voluntary ni creditor na binigay kay debtor yung condonation. 1272 naman ay whenever the private document in which the debt appears is found in the possession of the debtor, it shall be presumed that the creditor deliver it voluntarily. So, yun ulit, voluntary ulit yung sa pagde-deliver ng private document ng condonation. Number 1273 na article, the renunciation of the principal debt shall extinguish the accessory obligations, pero hindi yung principal obligation. So, mawawala na yung mga accessory obligations. Article 1274 naman, nagsasabi na it is presumed that the accessory obligation of pledge has been remitted when the thing pledged after its delivery to the creditor is found in the possession of the debtor or third person who owns the thing. So, kapag ka nakita mo ng nasa possession na ulit ng debtor or ng third person na may-ari dun sa bagay na yun, yung ipinledge na bagay, pwede mo nang i-presume na yung accessory obligation ay na-remit na. So, Section 4 naman ay confusion or merger of rights. So, Article 1275 says the obligation is extinguished from the time the characters of creditor and debtor are merged. So, yung creditor at debtor ay isang tao na lang. At yung Article 1276 naman, ang sinasabi niya ay merger which takes place in the person of the principal debtor or creditor benefits the guarantors. So, sinasabi lang nito na yung guarantors ang nagbe-benefit sa pag-merge ng creditor at debtor. So, confusion which takes place in the person of any latter does not extinguish the obligation. So, kahit na mag-merge yun, meron pa ring obligation kay guarantor. Next one ay Article 1277, which says confusion does not extinguish a joint obligation except as regards share corresponding to the creditor or debtor in whom the two characters concur. So, ang ibig sabihin lang nito ay sa isang joint obligation, kapag yung isang member ng joint na yon ay yung naging creditor at debtor, yung isang hindi creditor at debtor ay kailangan pa rin magbayad, which hindi pa rin siya tapos sa kanyang obligation.
Article 1278, ito sinasabi dito na bago mag-take yung compensation, kailangan merong creditors at debtors. Lahat creditors and debtors sila each other. Article 1279, ito naman yung mga ito yung mga kailangan para mag-take place yung compensation. Itong limang to. Ito yung mga requisite. Article 1280, yung sinasabi lang dito yung guarantor, pwede siya mag-set up ng compensation. May karapatan siya na mag-set up ng compensation between the two, the creditor and the debtor. Article 1281, yun, sinasabi dito pwede maging partial or total yung compensation. Depende sa dalawa. Kung partial, hindi lahat mababayaran yung obligation. Article 1282, pwede lang pag-usapan yung mga debts na hindi pa due. Pwede mag-take place yung compensation kahit hindi pa due nung isang debts ng isa. So, pwede na lang pag-usapan. Pwede sila magkaroon ng agreement doon. Article 1283, kung halimbawa nagkaroon ng kung may obligation ka doon sa isa, tas nag-cause ka sa kanya ng damage, pwede niyang gamitin yung damage na yun na parang magkaroon ng compensation. Article 1284, ito sinasabi dito, yung mga debts daw na pwedeng ma-void, ano pa rin sila, pwede pa rin sila take ng compensation hanggat hindi pa sila nananald or na-void. Article 1285, ito, sinasabi naman dito yung yung mga consent. Dito malalaman kung magte-take place ba yung yung compensation. Kailangan may consent lagi dun sa creditor para mas okay or may mangyayaring compensation. Article 1286. Ito. Dito naman kung sino yung sinasabi dito kung sino yung gusto ng nagde-demand ng compensation para magkaroon ng compensation, siya dapat yung siya yung magbabayad ng mga expenses, kanbawa sa mga tax, sa mga transportation. Yun. Article 1287, compensation. Ayun, halimbawa dito naman sinasabi, yung mga deposit, bawal siya gamitin sa compensation. Halimbawa nag-deposit ka sa isang tao, tapos nangungutang ka sa kanya. Bawal niyang sabihin na hindi niya babayaran, hindi niya ibabalik yung deposit mo kasi may utang ka sa kanya. Hindi yan pwede. Kaya pag kumoda to, halimbawa nang hiram siya ng sasakyan sa'yo, tapos nangutang ka sa kanya, bawal niya sabihin na hindi niya ibabalik yung sasakyan mo kasi may utang ka sa kanya. Yun yung sinasabi dito sa Article 1287. Sa Article 1288 naman, yun, bawal mong bawal gamiting compensation yung halimbawa nag-cause ka sa kanya ng offense or pero may utang siya sa'yo. Bawal mo sabihin na hindi kita babayaran, ay hindi na kita babayaran kasi may utang ka naman sa akin. Napag-usapan niya sa korte, kailangan mo siyang bayaran ng certain amount. Bawal mong gamitin yung utang niya sa'yo para hindi mo mapagampanan yung kailangan mong bayaran sa kanya. Dito sa 1 to 8 nang sinasabi lang na pwedeng piliin ng isang debtors yung mga utang niya kung alin din yung gagamitin niya sa compensation pag meron siyang several debts. 1 to 90, dito sinasabi pwede mag-take place yung compensation kahit hindi alam ng debtors at creditors basta lahat ng requisites nag-exist na sa Article 1279. Article 1291, ito naman yung mga obligation may be modified. Ito yun, mga pagpalit ng obligation, changing their object or principal, substituting the person or the debtor, subrogating a third person in the rights of the creditor. Article 1292. Ito, para ma-extinguish or mapalitan yung unang obligation, kailangan palitan ng di sinasabi palitan ng substitute. That same dapat. Article 1293. Maybe with. Ayun, kung pwedeng maglipat ng debtors, pwedeng ilipat yung debtors kahit hindi alam ng unang debtors, magkakaroon ng panibagong debtors. Basta alam may consent ng creditor. Yung sinasabi sa Article 1293. Tapos, kung ito naman, ito sa substitution. Yun, pag yung nagkaroon naman ng insolvency dun sa part ng new debtors, wala nang wala nang liability yung unang debtors dun. Kasi nagkaroon na ng consent dun sa creditor. Yung sinasabi sa Article 1294. Sa Article 1295 naman, sinasabi na yung insolvency ng new debtor, shall not revive dun sa bawal siyang ilip yung mga liability ng ng panibagong debtor, bawal mapunta sa original debtor except kung meron na talagang insolvency yung yung new debtor at alam na ng public yun. Tapos alam na rin ng debtor na may mga ganun nga siya. Article 1296, when principal obligation extinguished. Ito naman sa Article 1296, kung halimbawa napalitan na yung unang obligation, na-extinguish na ng panibago, yung benefits nun, dapat magsasubsist pa rin dun sa sa third person na kasi hindi niya naman binigay yung consent niya na ganun. Kung hindi niya alam na napalitan na yung panibagong obligation. Sa Article 1297, if the obligation is void, the original shall subs. Yun nga, pag yung syempre pag na-void yung yung original obligation, ay yung new obligation, yung original magsasubsist yun kasi syempre na-void nga, di ba? Article 1298, the novation is void if the original obligation was void. Syempre, hindi naman magkakaroon ng novation kung wala yung original obligation. Article 1299, if the original shall under the same condition. Halimbawa, pag napalitan yung yung original obligation, dapat same pa rin yung condition. Yun yung sinasabi sa Article 1299. Kahit may iba yung obligation, dapat yung condition same pa rin daw. Article 1300. Ito, sinasabi dito yung sinasabi na dito yung subgrupation. Meron daw dalawa, legal or conventional. Yun ang sinasabi. Ang subrogation ay yung paglilipat ng rights sa sa panibagong person. Article 1301, conventional subrogation of a third person required the consent of the original parties and of the third person. Yun, kung magkakaroon ng subrogation, dapat merong consent ng lahat ng doon, mga involved doon. Article 1302. Ito yung mga masasabi mong legal subrogation. So, when a creditor pays another creditor who is prepared, when a third person not interested in the obligation pays with the express or tacit approval of the debtor. When even without the knowledge of the debtor, a person interested in fulfillment of the obligation pays without prejudice to the effects of confusion to the latter shares. Ito naman sa Article 1303, subrogation transferred to the person subrogated. Ito sinasabi sa subrogation na to, napapasa na daw lahat ng rights dun sa third person na sinabrogate nila. At lastly, sa 1304, creditor, halimbawa, merong yung creditor, ang sinasabi dito, pag nagkaroon ng panibagong creditor yung debtor, kailangan prepared pa rin bayaran yung remaining balance niya dun sa una niya or original niya creditor niya.
So yung mga chapter nga na-discuss ko ay papasok dito sa title 2, which is contracts. So ang chapter 1 natin is about general provisions. So yung article 1305 na yung nagde-define ng contract. So a contract is a meeting of minds between two parties whereby one binds himself with respect to other to give something or render some service. So ngayon discuss na natin yung principal characteristics. Number 1 is autonomy of wills. Parties may stipulate anything as long as not illegal, immoral, or etc. Yung autonomy of wills na pala, nakakatulong siya para ma-regulate yung interest ng both parties freely at para mabuo rin yung legal relationship. Number 2 is mutuality. Performance or validity binds both parties, not left to will of one of parties. So, from its word na mutuality, dapat same yung relationship, same yung pagkakaintindi ng dalawang party. Number 3 is obligatory force. Parties are bound from perfection of contract. A is to fulfill what has been expressly stipulated. B is all consequences which may be in keeping with good faith, usage, and law. Number 4 is relativity, binding only between the parties, their assigns, heirs. Strangers cannot demand enforcement. So next naman is enumerate natin yung different kind of contracts. One natin as to perfection or formation, meron tayong tatlong contract doon, which is consensual, real, formal, or solemn. Number 2 is as to cause. Now, meron din tayong tatlong contract doon. It is onerous, gratuitous, 3 is remunerative. Number 3 natin as to importance or dependence of one upon another. Meron din tayong tatlo doon, which are principal, accessory, and preparatory. Number 4 natin as to parties obliged. Meron tayong dalawa, which is unilateral and bilateral. At yung huli natin, number 5, as to name or designation. One is nominate, And number 2 is innominate. Next naman is stages in a contract. Bale, may tatlo tong distinct stages. Yung preparation, perfection, and consummation. Sa preparation, nangyayari doon yung negotiation, which is nag-uusap yung both parties para sa kanilang interest. Bago yung perfection or birth, ito naman yung nangyayari. Nag-agree na yung both parties dun sa essential elements. Last naman is yung consummation, which is the last stage. Nangyayari siya pag yung yung both parties na fulfill niya na or na-perform niya na yung mga terms na pinagkasunduan dun sa contract.
Hello, I am Darosi. At nag-discuss ko ay Section 1, Consent, ng Chapter 2, Essential Requisites of Contracts. Ang Article 1319 ay tungkol sa consent. Ang consent ay nagmamanifest through offer and acceptance. Ang one party ay nag-offer and the other party accepted that offer. Nagkakaroon ng meeting of minds between two or more parties if the offer is certain and the acceptance is absolute. Pero if the other party counter-offers, ang tawag doon ay qualified acceptance. Ang 1320 naman ay meron two forms of acceptance. Express acceptance ay oral or written, while implied acceptance naman ay inferred or concluded mula sa act or conduct. 1321, ang offeror ay ang gumagawa ng terms of acceptance at kung gusto i-accept ni offeree ang offer, he or she must comply with it. 1322 ay kapag ang offeror ay nag-appoint ng kanyang agent to represent him sa offeree. Matatawag na acceptance ito sa oras ni-accept ni offeree ang offer ni agent. 1323, matatawag na ineffective ang offer kapag nagkaroon ng death, civil interdiction, insanity, or insolvency of either party before acceptance is conveyed. Ang civil interdiction ay kapag kinasuhan ng isang tao ng principal penalty not lower than reclusion temporal. Ang insanity ay legal term for mental disorder at insolvency ay inability or lack of means na makapagbayad ng utang. 1324 ay ina-apply sa situation na kung saan ang offeror ay nagbigay ng certain period of time sa offeree to accept. Sa 1325, kung hindi in-state sa business advertisement na isa itong definite offer, ito ay isang mere invitation to make an offer lang. 1326, kapag ang advertisement ay for bidders, ito ay matatawag na invitations to make proposals or offers. 1327, emancipated minors, which means minor below 18 years of age, ang insane or demented person at ang deep needs that do not know how to write ay ang mga tao na hindi pwede magbigay ng consent to a contract. 1328, sinasabi sa article na ito na valid ang contract kung ang insane or demented person ay nag-accept ng offer during lucid interval, which means temporary period of sanity. At voidable ang contract kung ang isang tao ay nasa state of drunkenness or during hypnotic spell. 1329, sa article na ito, nagre-refer sa mga explicitly disqualified by law from entering certain contract. 1330, nag-enumerate ng vices of consent such as mistake, violence, intimidation, undue influence, or fraud na makapagresulta sa voidable ng contract. 1331, about mistake or error, which means false notion of a thing or a fact material to the contract. Ang error or mistake ay kailangan na substantial, excusable, at mistake of fact and not mistake of law, dahil ignorance of the law excuses no one. 1332 protects the weak and disadvantaged. Kailangan na ang person enforcing the contract ay ma-explain ng maigi sa offeree na hindi marunong magbasa o magsulat o hindi alam ang language na ginamit sa contract. 1333, hindi matatawag na mistake kung ang party na nag-allege nito ay matagal nang alam ang doubt, contingency, or risk na maaaring maka-apekto sa contract. 1334, ma-apply lamang ang article na ito kung ang error ay mutual, isang legal effect sa agreement at ma-frustrate sa real purpose ng parties. 1335 ay about violence and intimidation. Natawag na violence kung mayroong physical compulsion na makapag-prevent sa
expression of the will at nakakapag-substitute ito with the material act dictated by another. While ang intimidation naman ay moral compulsion na nakakapag-influence ng operation of will. 1336 ay violence or intimidation na maaaring employed by a third person na hindi parte ng contract. Article 1337 naman, ito ay tungkol sa undue influence na kung saan ang isang taong makapangyarihan ay ginagamit ng kanyang advantage para i-overpower o i-subjugate ang mind ng another party para matanggalan ito ng freedom of choice. 1338 naman ay tungkol sa fraud through insidious words or machinations, which means deceitful scheme or plot na isa sa mga contracting parties. 1339 naman ay kapag nagkaroon ng neglect or failure sa pag-disclose ng facts kung ito ay duty na sabihin sa another party. Matatawag itong fraud. Sa 1314, matatawag na tolerated fraud at considered not fraudulent ang mga usual exaggerations ng trade or business kapag ang other party ay may opportunity to investigate. 1341, ang expression of opinion ay hindi matatawag na fraud, kwera na lang kung ito ay opinion ng isang expert dahil ito ay makonsider na fact lalo na kung maglalay ang other party na sinabi nito. 1342, ma-avoid ang consent na kung ang misinterpretation ng third person ay nakapag-create ng substantial mistakes about parties. 1343, ma-consider naman na mere mistake or error at not fraudulent kapag ang misinterpretation ay hindi intended. 1344, ma-avoid ang contract kung ang fraud ay serious at hindi pwedeng i-employ sa both contracting parties. Ang dolo, insidente o incidental fraud ay inobliga na ang gumawa nito na magbayad ng damages. 1345 ay tungkol sa simulation of contract, which means act of deliberately deceiving others. At ito ay maaaring absolute or relative. Ang absolute, when the parties do not intend to bond at all, while ang relative naman ay when the parties conceal their true agreement. And last, Article 1346, matatawag na void kapag ito ay absolutely simulated or fictitious contract. Ang relative simulation naman ay kapag hindi nagkaroon ng prejudice ang third person is not intended for purpose contrary to law, morals, good customs, public order, or public policy.
Lipat naman tayo sa Chapter 2, which is Essential Requisites of Contracts. Section 2, Object of Contracts. Objects, sinasabi dito ng objects ay prestation. So, bakit nga ba? Sinabi dito na, it is the conduct required to be observed by the debtor or the obligor, and it may be an obligation to give, to do, or not to do. So, ito nga yung list of requirements para ma-achieve yung object of contracts. So, dapat within the commerce of man, either existing or in potency, be licit or not contrary to law, good customs. So, in short nga, dapat lawful. Letter C, possible. Letter D, determinate as to its kind of or determinable without need to enter into a new contract. Dapat malinaw yung contract at dapat nandun na lahat. So, last nga natin is dapat transmissible. Next natin, Chapter 2 pa rin, and Section 3, which is cause of contracts. Causa, or what is the reason why parties enter into a contract. So, yung mga requirements nga para ma-achieve yun, syempre dapat it must exist, at dapat totoo rin, must be true, and C, it must be illicit or lawful. So, continuation tayo ng Section 3. Yung cause nga, masabi natin sa motive. So, motive is purely private reason. Illegality does not invalidate contract except when it predetermines purpose of contract when merged into one. So, punta naman tayo dito sa table. Absence of causa is void, so produce no legal effect. Illegality of causa naman, void din siya, produce no legal effect. Falsity of causa
voidable siya. So, ang dapat gawin, party must prove that the cause is untruthful, presumption of validity but rebuttable. So, next naman is cause not stated in contract, presumed to exist. Yung burden of proof is on the persona saying its existence. Natin is inadequacy of causa does not invalidate contract per se. So, ang exceptions natin, apat na exceptions. One is fraud, two mistake, three undue influence, four cases specified by law, contracts entered when ward suffers lesion of more than 25%. So, lipat naman tayo dito sa chapter 3, which is form of contracts. So, define natin yung form. Form in some kind of contracts only as contracts are generally consensual. Form is a manner in which contract is executed or manifested. So, yung form nga is a written document na nire-record ng law para sa validity. So, meron ka tayong tatlong form of contracts. A is informal, may be entered into whatever form as long as there is consent, object, and cause. Letter B is formal, required by law to be in certain specified forms such as donation of real property, stipulation to pay interest, transfer of large cattle, sale of land through agent, contract of antitrust, and so on. And last natin is yung real, creation of real rights over immovable properties and must be in written. So, when form is important, number 1 for validity. Number 2 is for enforceability. And number 3 is for convenience. Bale, yung form nga is important para ma-protect yung contract natin. Once na may mga reasonable na masilip yung ibang tao o yung mismong constitution, meron tayong mapapakita at meron tayong written na hawak para maipakita na magsaserve din na proof para doon. Ngayon, bale chapter 3 pa rin tayo. Nag-add lang tayo ng exceptions to form of contracts. Letter A natin, law requires contract to be in some form for validity, donation, and acceptance of real properties. Letter B natin, law requires contract to be in some form to be enforceable. Statute of frauds, contract is valid but right to enforce cannot be exercised. Need ratification to be enforceable. Letter C natin, law requires contract to be in some form for convenience. Contract is valid and enforceable, needed only to bind third parties. So, bigyan lang tayo example ng public documents needed for the following. Number 1 natin, contracts which object is creation, transmission, or reformation of real rights over immovables. Number 2 natin, cession, repudiation, renunciation of hereditary rights or CPG. Number 3 natin, power to administer property for another. Number 4 natin, cession of action of rights proceeding from an act appearing in public institution. Number 5 natin, all other documents where amount involved in excess of 500 must be written, even private documents.
Continue, I am Ranil A. Gamat and I'll be discussing chapters 4, 5, and 6. Start as chapter 4, Reformation of Instruments. Kapag sinabing reformation of instrument or contract, it means improvement of the existing contract dahil kung minsan may mga pagkakamali or hindi pagkakasundo kaya nire-reform ang isang kontrata. Article 1359, kapag may disagreement or may mali sa contract sa pagitan ng dalawang partido, pwede nilang i-reform ang kontrata kung magkakasundo sila or di kaya naman i-annul or i-terminate ang contract kung hindi sila magkakasundo. 1360, yung General Law of Reformation of Instruments dapat sang-ayon sa Code ng Obligations and Contracts. 1361, kapag may pagkakamali ang pares na partido doon sa kontrata, pwedeng i-reform yung contract. 1362, kung ang isang partido ay nagkamali, either para makapanloko o itago lang yung pagkakamali, yung kabilang partido, pwede silang mag-request ng reformation. 1363, kung ang isang partido ay guilty sa pagtatago ng pagkakamali, o kaya yung dalawang partido, parehas nilang hindi alam na may mali pala sa contract, pwede mag-request ng reformation. 1364, yung third person or yung gumawa ng contract which is hindi kabilang sa dalawang partido. Kapag may mali siyang nagawa sa kontrata, pwede mag-issue ang korte ng reformation. 1365, kung napagkasunduan ng dalawang partido na isang la o kaya ibigay ang kanilang ari-arian. Maaaring reform ang contract upang maging possible yon. 1366, bawal ang reformation sa simple donations, pamana o kaya kapag na-void ang agreement. 1367, kapag naman yung isang partido in-enforce niya yung original instrument or contract, hindi na pwedeng i-reform yun. 1368, pwedeng magkaroon ng reformation kung gusto ng magkabilang partido or kaya ng mga substitute or representative nila. 1369, tuwing may reformation ng instruments, dapat next, Chapter 5, Interpretation of Contracts. May mga pagkakataon na medyo magulo o di kaya may malabo sa kontrata. Yung chapter na ito yung paraan para maayos na ma-interpret ng contract. Article 1370, kapag malinaw ang nakasaad sa contract, walang hidden intentions. Yung literal na meaning ng words sa kontrata ang susundin. Kung hindi tugma yung intentions ng partido sa words na nasa contract, syempre yung intentions na yun ang susundin. 1371, malalaman ang intensyon ng mga partido kung titignang mabuti yung kasalukuyan at susunod nilang gagawin o ikikilos. 1372, kahit gaano ka-general ng mga words sa contract, hindi pwedeng unawain yon as something specific o kaiba sa napagkasunduan ng magkabilang. 1373, kapag ang isang provision sa contract nagtataglay ng higit sa isang kahulugan, kung anong kahulugan yung pinaka-applicable or pinaka-appropriate, yun ang gagamitin. 1374, ang iba't ibang provision ng isang kontrata ay ini-interpret bilang isang buo at hindi. 5, may mga terms sa isang kontrata na posibleng maiba-ibang meaning. Yung mga terms na yun dapat ini-interpret sa kung ano yung pinakamalapit sa katangian o layon ng contract. 1376, dapat i-consider yung kaugalian o nakasanayan sa lugar kung saan gagamitin yung contract, especially kung malabo o kulang yung nakaasaad sa kontrata. 1377, kapag may mga salita sa contract na malabo o magulo, hindi dapat makinabang doon yung partido na naglagay ng mga magulo o malabong terms. 1378, kung hindi uubra yung mga naunang article, 1370 to 1377, at ang contract walang mainam na batayan, kung sinong partido yung may mas kaunting pakinabang sa kontrata, siya ang mananaig. Kung ang kontrata naman hindi economical, yung mga pamahal palalo, kung saan na lang mas makikinabang yung dalawang partido, yun na lang yung susundin. Kung imposible lang namang malaman kung ano talaga ang intensyon ng dalawang partido, i-void na lang ang contract. 1379, ang nilalaman ng Rule 123 of the rules of court ay dapat ding i-consider kapag gagawa ng kontrata. 6. Resisable contracts. May iba't ibang classification ng defective contract. Ay yung resisable contracts. Kapag sinabing resisable, ang meaning niyan is pwedeng i-rescind or i-cancel. Initially, yan ay valid. Kaso, kung ang contract ay nakapinsala, abolish yung contract na yon, kaya magiging resisable contract na. Ang purpose ng rescission ay makakuha ng compensation mula sa damage caused by a valid contract. Article 1380, kapag napagkasunduan na i-rescind ng isang contract, pwede yung i-cancel as long as sangayon sa batas. 1381, i-cancel ang isang contract sa mga sumusunod na pagkakataon. Una, kapag yung property ng isang ward, yung ward is someone na kailangan ng guardianship, like mga bata. Kapag more than 25% ng property nila ay binenta halimbawa ng kanilang guardian, bawal yun. Pangalawa, kapag may absentee, ito naman yung mga hindi mahagilap, kapag more than 25% ng property nila ay binenta halimbawa ng kanilang representative, bawal din yun. Pangatlo, kapag ang contract sa mga fraud creditors, pwede rin i-cancel. Pangapat, yung mga bagay na under trial tapos ipinasok sa isang contract na walang approval, bawal din yun. Cancel ulit yung contract. Panghuli, lahat ng contract na dapat i-rescind ayon sa batas, syempre lahat yun dapat i-cancel. 1382,
ang payment contract o kasunduan sa pagbabayad sa pagitan ng nangutang at ng nagpautang pwedeng i-cancel. Pero syempre, yung nangutang dapat magbayad. 1383, hindi pwedeng basta-basta mag-cancel ng contract. I-allow lang yun kung ang partido na nag-suffer ng damage wala nang ibang paraan para ma-compensate yung damage na tamo niya. Or ang contract rescission nangyayari para lamang ma-resolve yung damage na nangyari sa isang partido. 1385, ang layunin talaga ng contract rescission ibalik initial na nilalaman ng contract. Kung ang kontrata ay nasa pangangasiwa ng ibang tao, third person, na wala namang ginawang masama, imposibleng mangyari ang rescission. Kapag ganoon yung case, kung sino yung may ginawang masama, yun ang dapat managot. 1386, at sa absentee, korte na yung gumawa ng contract sa situation na yon, yung 1 and 2, syempre hindi na yun makakancel. Unless kung walang due process or kaya walang jurisdiction ng court specific case na yun. 1387, alienation or transfer ng gratuitous or onerous title can be considered as fraudulent. Gratuitous title ay property na dinonate while onerous title ay maaaring ibinili. Halimbawa, kung ang isang tao i-donate mostly ng property niya sa ibang tao at ang matitira sa magdo-donate hindi sapat para bayaran ng mga utang niya, hindi pwedeng mag-proceed sa donation. Kung ipagbibili naman ng isang property at yung magbebenta ay may pending na judgment or pagpapasya mula sa korte, hindi rin pwedeng mag-proceed sa pagbebenta. 1388, kapag ang isang tao na tatanggap o bibili ng property, alam niyang may panlolokong nagaganap behind the transaction, tapos nag-proceed pa rin siya, kailangan niyang isauli yung property o bayaran yung creditor na naloko ng nag-donate o seller ng property. 89, dapat mag-umpisa ang process ng rescission within 4 years. For those na nangangailangan pa ng guardianship, yung mga ward na tinatawag, mag-i-start lang kapag nasa legal age na sila, while yung mga absentee, syempre kapag sila ay nahagilap na.
Good day, I am Evander Laneta. So move on na tayo ngayon sa Chapter 7, which is yung voidable contracts. So according to Article 1390, ang anumang kontrata ay maaaring ma-void, ma-annul, ma-invalid, or mabaliwala kahit pa wala namang damage na nangyari doon sa magkabilang partido kapag ang alinman doon sa dalawang parties ay walang kakayahan na magbigay ng consent or pahintulot para doon sa kontrata. Hindi ay kalawang kondisyon, maaari ding mabaliwala yung kontrata kapag yung consent ay nabahira ng isang malaking pagkakamali, violation, intimidation o anumang fraud o panloloko o pagtatakip sa katotohanan. Sa Article 1391 naman, ang action daw para sa annulment ay dapat magawa within 4 years. So the period shall begin in cases of intimidation, violence, or undue influence from the time the defect, if the consent ceases. So, Article 1392, ratification extinguishes the action to annul or voidable contract. So, ratification means approve formally, maaaring ma-extinguish nito or ma-stop nito yung action ng pag-annul dun sa isang voidable contract. Article 1393, stated dito na, ratification may be effected expressly or tacitly, and it is understood that there is a tacit ratification if, with knowledge of the reason which renders the contract voidable and such reason having ceased, the person who has a right to invoke it should execute an act which necessarily implies an intention to waive his right. So moving on sa Article 1394, ratification may be effected by the guardian of the incapacitated person. So if ever na yung isang tao na involved ito sa isang kontrata, wherein magkakaroon ng isang formal na approval or kasunduan, ay incapacitated, pwedeng umassist yung guardian sa kanya. So, Article 1395, ratification does not require the conformity of the contract party who has no right to bring the action for annulment. So, Article 1396, ratification cleanses the contract from all of its defects from the moment it was constituted.
So, ayan. If ever na yung contract ay mayroong mga defekto and nagkaroon na ng ratification, after nun, babaliwala na yung mga depekto na yun the moment na ma-constitute or ma-sanction na yung ratification na nagawa. So Article 1397, the action for the annulment of contracts may be instituted by all who are thereby obliged principally or subsidiarily. However, persons who are capable cannot allege the incapacity of those whom they contracted, nor can those who exerted intimidation, violence, or undue influence, or employed fraud, cause mistake based in their action upon this clause of the contract. Article 1398. So, an obligation having been annulled, the contract parties shall restore to each other the things which have been the subject matter of the contract, with their fruits and the price with its interest, except cases provided by the law. Article 1398, according dito, after na ma-annul yung obligation, contracting parties ay dapat ma-restore yung mga bagay na hindi subject matter ng contract. Article 1399. The defect of the contract consists in the incapacity of one of the parties. The incapacitated person is not obliged to make any restitution except insofar as he has been benefited by the thing or price received by him. According to Article 1399, kapag ang isang depekto ng isang kontrata ay nagkukonsist ng kawalan ng kakayahan ng isa sa mga nasa partido, ang taong iyon na hindi na inoobliga pa ng makapaggawa ng restitution except sa ng benefit dun sa bagay na naging dahilan ng depekto. Article 1400, kapag ang isang tao na inoobliga ng diktain ng alamin na ibalik ang isang bagay at hindi niya ito na ibalik sa kadahilan ng siya rin ang may kagagawa nito, dapat maibalik niya yung fruits na na-receive katumbas na halaga ng oras na nawala at ng mga interes sa parehas din na panahon. Article 1401. The action of annulment of contracts shall be extinguished when the thing which is the object thereof is lost through the fraud or fault of the person who has right to institute the proceedings. If the right of action is based upon the incapacity of any one of the contracting parties, the loss of the thing shall not be an obstacle to the success of the action, unless said loss took place through the fraud or fault of the plaintiff. Article 1402. As long as one of the contracting parties does not restore what in the virtue of the decree of annulment he is bound to return, the other cannot compel to comply with what is incumbent upon him. Ayan, according naman sa 1402, hanggat daw hindi na ibabalik or nare-restore na isasaayos ng isa dun sa mga contracting parties kung ano man yung napagkasundoan na dapat maibalik. So yung other side naman ay hindi pwedeng pilitin o obligahin na mag-comply kung ano man yung posisyon na nakaano sa kanila. Moving on sa Chapter 8, which is yung unenforceable contracts. According to Article 1403, ang anumang kontrata ay unenforceable or hindi pwedeng ipatupad or maging epektibo unless they are ratified kapag ang isang tao na pumasok sa kontratang iyon ay gumamit ng pangalan ng ibang tao na merong otoridad or legal representation and nag-act beyond sa kanyang kakayahan. Article 1404, unauthorized contracts are governed by Article 1317 and principles of agency. Ayan, so according sa Article 1317, wala daw pwedeng pumasok sa isang kontrata gamit ang pangalan ng ibang tao unless siya ay pinayagan ng tao na yon with a formal ratification or sanction. According to Article 1405, there's a contract that infringes statute of frauds, which referred to number 2 of Article 1403. It will be ratified by the failure to object to the presentation of oral evidence to prove the same, or by the acceptance of benefits under them. Article 1406. When a contract is enforceable under the statute of frauds, and a public document is necessary for its registration in the Registry of Deeds, the parties may avail themselves of the right under Article 1357. Article 1407. In a contract where both parties are incapable of giving consent, express or implied ratification by the present, or guardian, as the case may be, one of the contracting parties shall give the contract the same effect as if only one of them were incapacitated. If ratification is made by the parents or guardians, as the case may be, of both contracting parties, the contract shall be validated from the inception. Article 1408. Article 1408 states that unenforceable contracts cannot be assailed by third persons.
My name is Nathaniel Alumbro and ang report ko ay ang Chapter 9 ng Title 2 Contracts, which is void or inexistent contracts. So, ano nga ba ang void or inexistent contracts? So, void contracts. Those which of certain defects generally produce no effect at all. So, no effect means wala itong legal binding effect as it does not create, modify, extinguish a judicial relation. So, walang rights na nag-grant and walang obligations na nabuo. Inexistent contracts. So, this refers to agreements which lack one or some or all the elements or do not comply with the formalities which are essential for the existence of a contract. So, ano nga ba yung elements na naglalak? Let's move on sa kinds of void or inexistent contracts para malaman. So, kinds of void or inexistent contract. So, number one, those lacking in essential elements. So, ang mga elements na ito ay ang no consent, no object, and no cause. So, nakalagay ito sa Article 1410 and ang consent means agreement to the same thing. So, sa isang void contract, either ang isang party ay hindi payag o hindi alam na may contract. Object of a contract, ito yung mga bagay na matatanggap ng either party, maaring pera, maaring service. And no cause, yun naman yung walang pinagmumulan. So, ano mga example nito? Una, those which are absolutely simulated or fictitious. So, fictitious siya, so hindi siya totoo. Kaya no cost. So, next, those which cause or object did not exist at the same time of the transaction. So, ito yung gagawa sila ng contract pero wala namang palang pera or service na pampalit. Next, those whose object is outside the comments of man. So, no object ito. Since yung mga bagay na outside the comments of man, ay yung mga public property. So, hindi naman natin pwede gamitin yung public properties pampalit sa isang contract. So, next, letter D. Next, letter D, those which contemplate
Nangyari. Ano nangyari?
Sir, nawala daw po yung internet ni JJ po.
Sige.
Pero ay, sorry po.
Sige, ano yan?
Huling reporting na po yun, sir.
Oo, ayun nga. Meron pa natitirang 4 minutes na lang naman, no? So, sige, nandun naman sa group yung sa GC yung chat. Yun, yung gusto nyong pakinggan yung last part. So, meron na lang natitira dong 4 minutes. Last reporter siya. Doon na lang pakinggan kasi past time na rin tayo. So, ayun, yun yung for today. May mga magagandang discussion na nabanggit. So, tama naman yung naging coverage nila ng kasi part lang siya ng penal code ata to eh. Part lang siya ng Civil Code of the Philippines. So, nasa ilang libong articles kasi yun. So, tama lang na obligations and contract yun nila. So, na lang ulit, check na lang or pakibigyan na lang din ulit sila ng evaluation dun sa Google Forms. So, isasend ko na lang ulit dito sa GC. And then, yun na lang yung for today. So, huwag na tayo mag-quiz kasi late na. So, ayan. Huwag na, hindi na natin itutuloy. Yung na lang gusto pakinggan, doon na lang sa GC. Okay? So, yun. So, thank you sa mga naging reporter sa nag-discuss ng mga assignment. So, yun na. Paki-evaluate na lang and then yun lang for today. Yun. So, kung wala ng questions and then nakapag-evaluate na, pwede nang mag-exit tayo.
Thank you po, sir.
Thank you po.
Thank you po, sir.
Thank you po, sir.
Thank you po.
Sige. So, ayan. Thank you.